We're going to go ahead and get started with our first speaker, who we're very glad to have here, Steve Schulman, who's on the National Appleseed Board and with Akin Gump, and is responsible for recruiting, I'm going to guess, probably hundreds of lawyers to help on immigration cases across the country. And he handles immigration cases himself. Very experienced, very knowledgeable, and we're very fortunate to have him today. And I'm going to hand it over to him so he can talk a little bit about what actually happens with immigration detention and some of those other issues. So thank you for being here.
Thank you. Thanks for having me. So my name's Steve Schulman. I have the great pleasure of being the co-chair of National Appleseed. And I feel like this is a little bit, those of you who know the old hair club for men, where the guy says, I'm not just the president, but I'm a proud member. I'm actually not just the board co-chair, but I'm a proud pro bono volunteer for Appleseed, which is really, as much as I've been involved in the organization on an organizational level, I still think of myself really as a volunteer for Appleseed. And I'll talk in a moment a little bit about Appleseed and the work that I've done there. First, let me get a sense of the group here. How many people have worked on some immigration matter here before? So about half or so. How many people have actually been in an immigration court? A little less than that. Okay. So this gives me a good sense of the group here. So my own background is I was a fourth-year associate. I'm a litigator by training, and I started off. I graduated law school in 1994, and had never done any immigration work. Didn't even know. I had never taken an immigration law class, and I was in a litigation lunch as a fourth-year associate, and somebody said, "We have an asylum case going to trial. Would somebody like to do it?" And I think I heard the word trial, so my hand went up automatically. And it ended up being a case for a Nigerian pro-democracy activist who had been jailed and tortured in Nigeria. And I had really no idea what I was doing. This was, and again, I'm going to date myself a little bit here, this is before anything was on the internet except for things that you shouldn't look at work and maybe CNN. So there really was no way to get information about immigration or immigration courts or anything or asylum online. But somehow we prevailed on that case. We got asylum for the family. And those of you who have had pro bono cases and clients that last, you think kind of last forever, I will tell you that case was in 1998, and I am now representing the daughter of that client, who is now herself an adult. She was 8 years old when she came here. I'm now representing her, not in an immigration matter, thankfully, although I'm representing her husband to get his green card because he's from Nigeria. So I'm my second generation of that client. But a lot of that experience has kind of informed my career since then, both from a sense of I went from doing antitrust and white-collar criminal to having a pro bono, side pro bono docket of doing mainly asylum work. I eventually became, my old firm, Latham & Watkins, became their first firm-wide pro bono counsel, and then 10 years ago went over to Akin Gump, where I am in Washington, and I manage firm-wide the pro bono practice, the pro bono partner on a full-time basis. And about 25% of our firm's pro bono docket is immigration-related work. So I have now had the great fortune of working on really hundreds of immigration matters. Probably the most significant one, and I'll talk a little bit about this throughout the presentation. In 2014, we were part of a group of firms that got involved when Central American women and children were coming over the border, and a bunch of them were detained in Karnes, Texas, which happens to be about an hour from our San Antonio office. So we immediately deployed folks there. We actually sent an associate to work there full-time for about 4 months while the local legal services people were able to get that settled. And I made about 7 trips to San Antonio that fall and got very involved, and I'll talk a lot about kind of that, because that experience of the detained population, I think, will help you kind of understand what you can do from this aspect. On the Appleseed side, I have been involved in a lot of immigration policy matters as well. Those of you who are not familiar with Appleseed, Appleseed is a network of 17 public interest justice centers. One of our crown jewels of the network is here in South Carolina. And Appleseed really, one of the great benefits of it and challenges in describing it is it's not just one thing. It really is locally based organizations that look at all the tools in the toolbox, using a lot of pro bono work, but using advocacy, litigation, community building, and figuring out how to right wrongs, how to make government work better, how to make the system more fair for everybody, but especially obviously low-income individuals. One of the things that we're going to talk about later today, I believe Jim Harrison is going to address this after lunch, is one of our great projects, which is protecting assets in child custody for people in deportation. This was a manual that came out about 5 years ago. It was somewhat prescient, and with the new administration, we have redoubled our efforts to update the manual, have folks, more than a dozen law firms working with us to update the manual to reflect different state practices in child custody and asset protection. So you'll learn a little bit more about that today. As I was talking about, the issue with Appleseed that I've become most involved in has been the immigration courts. And again, obviously, having practiced in the immigration courts, it became very obvious to me what the flaws were, and joined in with some other lawyers and firms to work not just on immigration courts. We also did a report called Children at the Border, which looked at the way that Mexican children were being treated under the Trafficking Victim Protection Reauthorization Act, whether they were properly being sent back to Mexico, and then working with Mexico Appleseed to see how they were treated in Mexico. We also did a report on the DACA process, so looking at the way that DACA was implemented, and in a bit of hope, we're kind of anticipating the DAPA program, which never got implemented, but we're recommending ways that program could work better in its implementation. And we've also looked at problems in the detention system, and I'll talk a little bit about detention as well. We did a big report with Texas Appleseed on representing or the treatment of individuals with mental disabilities, both in immigration court and in the detention system. In the immigration court reform area, we've focused really on 5 key areas. One is discovery, and as I'll discuss in a little while, there essentially is no discovery in immigration court. It's called the Freedom of Information Act. Pre-hearing conferences, which don't happen nearly enough, but should happen more to resolve cases. The use of video conferencing, which is particularly prevalent among detained populations. Interpretation, which is really one of the big challenges in practicing in immigration court. When you think about it, you are in a court where most likely the person who is being represented, who is the subject of the matter, actually does not speak the language. They are guaranteed interpretation provided by the court, but there are real challenges to it. And then we've done a lot of work on immigration judge, which is what IJ stands for, immigration judge and DHS attorney misconduct, and the ways to remedy that. And we also have a national bond representation program. Our most recent guide on the immigration courts, and I'm not going to talk about that in detail today, but is our guide called Getting Off the Assembly Line, which is the title of this presentation. That is one that looks at, instead of looking at the systemic issues along those 5 areas, what it does is talk to practitioners, and we talked to practitioners all over the country and got tips from them on how to overcome issues if you're representing somebody who's being video conferenced. One of the questions is there, for example, if you're representing somebody who's being video conferenced, do you go sit with your client on the video conference, or do you go to court? And those are difficult decisions to make. If you can do it, one of the recommendations from practitioners is have somebody with the client and have somebody in court. Obviously, that doubles the number of personnel you need to have on the case, but that can obviously be the most effective. So those are the kind of tips we give in there, but I'm going to go a little more basic in this presentation, given that a lot of you haven't worked on immigration yet. And so I don't want to kind of overwhelm you with kind of all the insider's tips, but that guide is available, and I think it's a great resource. So today what I'd like to accomplish is making sure that you understand enough to know how you can help. And we're going to talk today about how you can help, not just for some of you who have been in immigration court, going back to immigration court and doing that, but how you can help from afar as well. I'm certainly aware that there are no immigration courts here in South Carolina, so you've got the closest one in Charlotte, which is a non-detained docket, and people here who would be picked up by immigration would most likely be at least initially detained at the Stewart Detention Center near Atlanta, and then the hearings would be in Atlanta, which obviously are far afield, and the most committed among you might actually want to go to Stewart and work in Stewart, but that might be very difficult. And so how can you help from afar, I think, is a much more practical issue. So we're going to go over some of the immigration law basics, what the agencies are, the terms, the sources of law. We're going to talk about immigration detention, which obviously is a huge issue right now with immigration enforcement ramping up this year. We're going to talk about the who, where, and why of detention. We'll go over the immigration court process so you understand what that looks like, how the process works, and how you can help with that. We're going to look at release from detention, which can be a very critical part in representing somebody, what kinds of relief you can get, and ultimately removal. And then the work product, basically how you can help from afar. So some basic immigration terms for those of you who aren't familiar with them. Alien is the technical legal term under the law for somebody who is not a U.S. citizen. So it's not a pejorative term. It can be kind of used pejoratively. An arriving alien is somebody who is presenting at the border, who is actually here at the border, and I'll talk in a moment about why that's important. A non-resident alien means somebody who is here legally but is not a resident of the country, so a visitor visa, students. And then resident aliens are people who have the right to live here, legal permanent residents, and others with long-term visas. Another term is immigrant versus non-immigrant, and these are visa categories. So in the technical legal terms, an immigrant is somebody who is coming here with the intention of staying here more or less permanently. A non-immigrant is somebody who is coming here and intending to go back to their home country. So someone on, for example, an H-1B visa, if they're not going to adjust status to a green card, would be a non-immigrant visa. B1, B2 visitors, obviously those are both business and tourism visitors, those are non-immigrants. Immigrant visas are typically family-based visas and others who are coming here to stay permanently. A legal alien, as you probably know, is a politically charged term that is not a term that's recognized under law. Probably the more kind of friendly term is undocumented alien, although that's not a legal term either, but at least it describes somebody who doesn't have documentation. The legal terms are status, so either you have status in the country, and that can be anything from a tourist visa while you're here, that's your status, and then you can be out of status. And if you're out of status, that could mean you never had status, but you could be out of status. Then adjustment of status is going from one status to another. So typically people who are adjusting status, for example, you may have come here on a student visa, you get married to a U.S. citizen, you would then adjust status to legal permanent residency and eventually citizenship. And those are LPR and USC are abbreviations for legal permanent resident. You may know this, LPR is essentially a green card holder. Green cards, by the way, are not always green. Some years they're green, some years they make them different colors. But they aren't necessarily green. But legal permanent resident is someone who has the right to stay here indefinitely, although that right can be taken away by an increasing number of criminal violations that can result in them losing their LPR status. And I'm not going to talk about that here today, but that is increasingly why it's important for people who are LPRs, who are eligible to become citizens, because even what we would consider relatively low-level criminal activity that is sympathetic can result in mandatory revocation of an LPR status. And there are terrible stories about people who have been basically kind of shoplifters who had a compulsive shoplifting addiction, have been here since they were small children, being sent back to countries that they didn't know anything about. So that is, I want to just put that in your mind, that one of the things that if you're ever representing somebody or know somebody who is an LPR and says, oh, I don't really need to become a citizen, yes, it's expensive, but it's more expensive to be deported, and even something like DUI could end up with getting somebody deported. The next term, arriving, entered, and what's pronounced as called EWI, or entered without inspection. So this is important from a legal perspective in terms of what your rights are, on your due process rights. Someone who is an arriving alien, think of them as somebody who is essentially at Heathrow Airport. They have no better rights when they're at Heathrow than when they land at JFK and are standing in line to get in. They are kind of figuratively and legally outside the country still, even though they have landed in the United States. They are called an arriving alien, and they only have certain rights, and this will be important for bond. They are not eligible for bond if they are detained, because they are still considered, even if they're detained and sent to Stewart, Georgia, they're still considered never to have entered the United States. Entering the United States is the physical act of either being admitted, which is crossing the border, having your passport stamped, or otherwise being paroled in and admitted, or entering unlawfully, which is EWI, entered without inspection. So this is one of the things at Carnes. We were dealing with women who mainly, the women, and these were from what are known as the Central Triangle countries, Honduras, El Salvador, and Guatemala, had crossed the border, the Rio Grande typically, with the help of coyotes or smugglers who were helping them get across. Really think of them more as guides. We're not talking about criminal, well, I mean, it is criminal, but we're not talking about drug smugglers. These are just people who are helping other people get across the border. So they get across the border, they would step on US soil. Typically these women would actually be looking for a CBP officer to turn themselves in so they could claim asylum. And they were, for legal purposes, had entered the United States. We had another, so those women were actually, and we'll talk about bond in a little bit, were eligible for bond because they had entered the United States, they had certain due process rights. We had other women who were at Carnes who had actually done what we would, I think of as the right thing, had walked up to the border, right to the border, and said, I'm here, I need protection, I'm here to apply for asylum. They were mentioned they were not eligible for bond because they were an arriving alien and considered still to be outside the United States. So they were an applicant for admission as opposed. It is completely counterintuitive unless you think back at what that fiction is about having entered and not entered. So that is the difference. The next term, these are equivalent terms, removal and deportation. Removal is the technical term for deporting somebody from the United States that is used as removal. So the agencies that are responsible for enforcement of our immigration laws. How many people here have heard of the INS? How many people here still think the INS exists? Good, okay. It doesn't, although you still can find forms, federal forms that refer to the INS. You still hear people talking about the INS. It has not existed in about 14 or 15 years. The Department of Homeland Security was created by the Homeland Security Act after 9/11. And basically took out of, INS used to be in the Department of Justice, and its history is important because of the Department of Justice did retain one bit of immigration enforcement, which are the immigration courts. But it used to be all within the Department of Justice. Now it is split between DHS and the Department of Justice. DHS is then broken up, as you may know, into dozens of agencies, not all involving immigration. Those that do involve immigration are Customs and Border Protection, CBP. CBP is what we think of as the Border Patrol. They are the folks both at the border in the airports, but also patrolling the border, mainly on our southern border, but also our northern border. And they are, again, responsible for initial apprehension at the border. U.S. citizenship and immigration services, also known as USCIS, think of it as the friendly face of DHS. It is the face that grants benefits, so work authorization, citizenship, asylum office, other immigration benefits, travel documents, everything else, anything that you think of as a benefit that's being given is most likely being given by USCIS. And then there's ICE, which you, I assume, have heard of. They are responsible for apprehensions internally within the United States. They are also responsible for detention and removal and for prosecution in the immigration courts. So they are the prosecutors. The immigration courts are within the ICE structure. The Department of Justice then was left with an organization called EOR, that's how it's pronounced, like the donkey from Winnie the Pooh, and it is sometimes just as forlorn as that donkey. EOR is the immigration courts. There are 59 across the United States. Again, the closest here are Atlanta and Charlotte. We'll discuss the whole system, but the next level of the appellate court is the Board of Immigration Appeals. And actually within the Department of Justice then, ultimately the Attorney General has ultimate authority over any laws, any interpretation of laws. So the Attorney General, and I would not be surprised to see Attorney General Sessions take cases. The Attorney General can take cases, him or herself, and decide those cases as precedent cases, taking them essentially away from the BIA or reviewing the BIA's cases. And that goes to basically agency law. That's what DOJ, when the Executive Office of Immigration Review adjudicates these, it is agency law that it's creating. So if you go back to your law school class on admin law, it's all Chevron doctrine and all those types of things that we look at in the federal courts. Okay, the sources of law then are U.S. federal, and again, this is administrative law. So the statutes are 8 U.S.C. Is the Immigration and Nationality Act. I should mention that it's one of those fun statutes that is numbered differently if you call it the INA versus 8 U.S.C. And it doesn't always correspond very easily. It's not like you can just subtract a certain number and get at the right number for the INA. So just be familiar with that. So I tend to just use the 8 USC sites rather than the INA sites. The regulations are found in 8 CFR, and those are both regulations issued by Department of Justice and DHS. So that is actually a 2-agency CFR. There are also policy directives and manuals. These are ones that are not kind of as well known, but if you are practicing either in immigration court or at the asylum office, both of these are available online and are incredibly useful tools. Especially the Immigration Judge Bench Book has in it decision templates for the judges, and they use those often. So if you're practicing before a judge, you should know what they're looking at. And those are fully available on the EOR website and also on the DHS website. BIA decisions are in what's called the INN Reporter, the Immigration Nationality Reporter. The BIA decides thousands upon thousands of cases a year, but only publishes about 30 to 40 cases a year, which makes it an incredibly frustrating body of law to deal with. It is the only published immigration law, except the AG publishes too, but that's published in the same place if the AG issues a decision. So you can find, immigration judge decisions at that level are not published at all. They're not precedential. You can find some around the web. Occasionally, they're printed in different in different periodicals, but they are just a matter of kind of influence. Same thing with unpublished BIA opinions. Those are not considered to be binding at all.
Who does the selection?
Huh?
Who does
the BIA selects?
selection?
Yeah, the BIA selects itself. It selects for precedent. I've actually had cases where I've asked the BIA to issue a precedent opinion and they've rejected it. Again, it's given the scope of what they do and you think about kind of the various issues in immigration law, there are many that they just don't decide a case for years on those issues. It can be a very frustrating part of practice. The case law that you deal with in the BIA, because the appeals ultimately go up to the federal courts of appeals, are the jurisdiction over either the asylum office, or it's actually, if you're in the asylum office, it's where your client lives at the time the asylum office decision is being rendered, or in the immigration court. So if you're in Atlanta, it's in the 11th Circuit. If you're in Charlotte, it's in the 4th Circuit. So an IJ case that is decided in Charlotte gets appealed to Falls Church to the Board of Immigration Appeals, then goes to the 4th Circuit, although that is the same circuit it would be if it was in Falls Church anyway. But an example, in Atlanta, you would appeal from the Atlanta immigration judge to the BIA back to the 11th Circuit with that. And then the BIA would need to follow 11th Circuit law as it's reviewing your case. And there are circuit splits and different circuits interpretations of the INA. So you have to be cognizant of that as you're practicing. And then there's international law as well. It's funny because a lot of law students who you meet say they want to practice international law, I think, because it sounds really exciting, like you might get to travel somewhere really cool. But at the end of the day, like most law that we practice at most firms, even if we call it international law, is not decided under necessarily international laws. It may be international deals we're doing that are decided under one country's law. But this is truly international law. While our statute, for example, the Refugee Act, comes right out of the Refugee Convention. And so it's important if you are practicing in the protection regimes, the Convention Against Torture or Asylum or Withholding of Removal, that you familiarize yourself as well with some of the international regimes there. The one thing I'll mention, I'm not going to go into detail on the asylum office thing here. I'm focusing more on immigration court. But for those of you who are interested in representing people who are applying for asylum initially at the asylum office, those are non-adversarial interviews. They are not litigation, and they are done in an office with an interviewer. I should mention that the asylum office it's a benefits office only, so it's part of USCIS. They don't remove people, they don't litigate issues there. All they do is either grant asylum or not. Now, if your client is out of status and they're not granted that benefit, they will be put in removal proceedings because they're out of status, but not because asylum was denied, but because they're out of status. If they apply and they're in status for asylum, nothing happens. They just don't get it. If they don't get it, if they get it, they get it. Does that make sense? So the asylum office is basically just a benefits office. And if they know that you're out of status, that your client is out of status, and they don't grant asylum, then you can be referred up to the immigration court at that point because you're removable.
Are these the folks that consider asylum requests made overseas?
No. So asylum. That's called refugee processing when it's overseas. The law is exactly the same, but when you are here in the United States, you apply to the asylum office. If you're overseas, you have to be designated a refugee by UNHCR and then put in the resettlement pool, and then those folks get essentially vetted by DHS over a multi-year period and then brought to the United States as refugees. But if you're here in the US, for example, my client who I mentioned, my Nigerian client, had come over here, had fled Nigeria, had a visa to come over here for a conference, I actually don't remember if he actually went to the conference, but he came over here, applied for asylum at the asylum office. He did prevail at the asylum office. They referred him to the immigration court, but he was allowed to apply to the asylum office because he was within the borders of the United States. So that is the key part here. So the first part I want to talk about is detention. That is obviously a specter that hangs over many communities here in the United States, is the fear of detention. I know it's probably hard to read from afar, and we'll go through this process, but this is a graphic that shows essentially what immigration detention looks like. Detention is both at the border, so there's border apprehension, and that's against CBP, and interior apprehension by ICE. And those are the things that we tend to think of as raids, and we'll talk a little bit later about raids and how you can become involved. Immigration detention is supposed to be civil detention, and there are some civil detention facilities, but the vast majority of immigrants who are detained in jails. There's no, we call it detention, it's essentially jailing in prison. This is Polk County. I visited, I guess had the fortune, I don't know, misfortune of visiting many detention centers. This may be the worst I've ever been to. This is a little bit outside of Houston, and maybe one of the most depressing places I've ever been. The cells were 8 people to a cell that was about the size of a maybe partner office in a law firm, and they were allowed out of that cell 1 hour a day. Otherwise, they spent all the time in there, and had a glass window that looked into the hallway, and it really reminded me mostly, and I hate to say this, but it was so dehumanizing. It reminded me of walking through like the reptile thing in a zoo, where you were kind of looking through the glass at these, caged people who mostly, even though we were there in the middle of the day, were sleeping because I guess they just had nothing else to do, being crammed in there. But those are, and this again is the key thing, is this is civil, not criminal detention. It's not supposed to be punitive detention. The ICE detains about 400,000 plus immigrants a year. The daily population is at least 35,000. There actually is a bed mandate that they have to fill a certain number of beds, or have to be at least paid for a certain number of beds around the country. And the cost is around $100 or more a day per detainee, that are paid both to private prison companies, to local counties, and state, and also state-run jails. Interestingly, as I was doing this presentation, I never really focused on where ICE apprehensions come from. 114, last year in fiscal year 2016, so which ended in September 2016, ICE apprehended 114,434 individuals. Interestingly, only 20% of those, so about 25,000, no, less than, yeah, about 25,000, 22,000 maybe, were actually in the community. Were actually people who they went out and got. Otherwise, they were just the passive, in a way, the passive recipient of people who had been jailed in the U.S. On a criminal charge and then transferred to DHS. One thing you should know, and likely many of you know this, but if you're an immigrant who's charged with a crime in the U.S., you go through that whole system. You don't get deported because you've been charged. You get prosecuted by the state or federal government. You serve your sentence, and then you go into immigration detention. So there's no kind of shortcutting the U.S. criminal justice system in that way. Yeah.
I'm finding that not to be the case right now. Like for example, in Lancaster County, there's a guy that got picked up by ICE who was just charged with a crime. He had no priors whatsoever, and then they shipped him off.
Oh yeah, no, that's, sorry, let me be more clear on that. What I'm saying is, as a matter of prosecutorial discretion, they may decide not to do it. But It's a matter of, if you commit a crime here, it's up to the prosecutor, I guess I should
No,
say.
I was the prosecutor on the case, and they just picked the guy up.
Oh, I see what you're saying is they
said,
took,
hey, you picked your guy up, I just took him.
oh, and they wouldn't let you
And I was
prosecute
just like,
him.
okay, I guess I'm supposed to keep this warrant pending while he's in removal, I don't know. But yeah, that's
Oh,
pretty common in
interesting.
the state.
That happens all the time. If they bond out on their state charges,
Then ICE is just
and there's
taking
an
them.
ICE detainer, 48 hours, they'll take him. They don't care
Yeah.
if the solicitor wants.
They won't actually allow the state to do it. Oh, interesting,
They
okay.
ship him to Georgia. and
I mean,
do it.
that's like, on
Yeah.
every case that I prosecuted where it was somebody, and where it could have been anybody from like just having, forged documents on them to, criminal sexual conduct with minors, anything, like shoplifting. If they consider them a priority, they're gonna put a detainer on them for 48 hours and take them to court.
Really? So they're gonna take them and not allow even serious crimes to be prosecuted?
Because what around here at least, and I don't know how it is in other states.
Yeah.
Around here, you've got 3 main facilities here that hold them, York, Charleston, and Lexington counties. But the other smaller counties, ICE will have like a working relationship with them, and then when somebody comes in who they think is undocumented, they'll go ahead and call the ICE
Right.
officers and report them. And then if they think the crime is serious enough, now prior to the January swearing-in date, if it was, fairly low offense, they didn't really deal with them if they could bond out. But now it's like anything, like a DUI, you're
Right.
gone, you're taken to court, that's it.
Right,
Like
interesting.
that is very common, like I've never seen them like go through trial or anything yet.
Yeah, interesting. So, I mean, that certainly sounds like both a bit of a change in policy, but also a little more radical than I thought that they were doing. So that 80%, I'm sure, includes what you're talking about, is people not just, being charged and then being taken, and obviously that's a whole separate thing with 287G agreements and other, we hear a lot about those, about sanctuary cities essentially who are not agreeing to hand over to ICE. Yeah. Yes, please.
I was telling Sue, I'm the guardian, or attorney for the guardians ad litem in family court abuse and neglect cases. And ICE has started showing up to our proceedings for the defendants, which is interesting.
Yeah.
Which are said no.
Right. Right. Yeah, they certainly are much more active in the community now, looking for, and that's been a clear message from this administration, is that they are not going to put any restrictions apparently on the way that ICE conducts its business. And the truth is, even under the Obama administration, ICE was relatively aggressive, at least as an institution, and so it had it was held back a little bit by some of the more senior officials in the government. But that is certainly consistent with what we're hearing nationwide too, is that ICE is essentially, as they've said, the gloves are off and they're going kind of wherever they want and however they want to get folks. ICE uses about 300 plus facilities in the United States, private, local, and state prisons to hold immigrants. And they also have recently proposed scaling back or abandoning what they call their detention standards, which are, again, civil detention standards. So they're supposed to be treating civil detainees different and have different rights if you are a civil detainee than a criminal detainee. And they are talking about just withdrawing those so that essentially if you are detained as an immigrant, you'll be treated just like anybody else who's in prison. Yeah.
Does that prison that you were showing earlier meet the detention standards, whatever the heck they are?
Some of those, not necessarily. They meet some of the standards, but they don't meet all those standards, no. They haven't always been enforced as
Yeah.
well, but at least there you have some, and I've done tours, the ABA has done tours over the years, the Commission on Immigration, and kind of reviewed these and at least had a voice in saying, we need to have improvements. That is one of the worst. It certainly was not complying with a lot of the detention standards. But there are things they were complying with, like having a law library, having the INA available.
If you have an hour a day to use it, that kind of limits you.
Right, it does, absolutely. So detention then there is mandatory detention of immigrants under 236C, actually that shouldn't be, that's INA 236C, I apologize again, I think it's 1136C. Crimes involving moral turpitude, aggravated felonies, and terrorism charges result in mandatory detention, meaning you can't be bonded out or paroled out by statute. And then post-removal order detention, if you have a final removal order and you're put in detention pending removal, that can be reviewed as of 6 months and must be reviewed per Supreme Court precedent called confidence. So there is a presumption that after 6 months you will be released unless there's a specific finding that you're a danger to the community or a danger to national security or a flight risk. So there is another way to kind of, if you have been ordered removed and yet they can't remove you, and that happens with some countries where they just can't get travel documents, they can't detain you forever. The relief from detention is parole, which is discretionary. And so we talked about those arriving aliens who are here. They have no right to bond, so they have to just ask discretionarily for parole. And then bond, which you can go before an immigration judge and prove bond. In terms of, before we talk about bond, as we talk about immigration detention, one of the questions is how do we find a detainee? There actually is an online ICE detainee locator. If you have the alien number, which is a number that is assigned that looks like a Social Security number, if you have that, it should be relatively easy to find it. The system's pretty good. I recently used this, I knew where my client was, but decided to kind of use it to test it out. And the A number worked, but the alternative way of doing it is you see at the bottom, search by biographical information, name, date of birth, and country of origin. The problem is it has to be an exact match to what DHS has in their system, and you don't necessarily know whether DHS put a typo in and I don't know why my client's name didn't come out when I put it in. So the A number worked, but my client's name did not work. And I don't know what in the system did it. So if you are helping somebody or trying to advise somebody, if you can't get the A number and you have to use the biographical information, your hit rate is probably about, what I'm told by other people, it's about 50%, the success rate. So just because you don't succeed on the biographical information doesn't mean the person's not in detention. It may just be that the information that is entered into the system isn't matching what you're putting into the system. It is not a kind of friendly, it's not like a Boolean search where you can say, well, Hernandez or Hernandez with an S or something like, you just have to keep typing it in, I guess, and see whether you can find the right match. So in terms of the way that folks get into detention, there are two different parts of the process, and I'm going to talk in a moment about what you might have heard referred to as expedited removal, which is a very serious part of the potential change in policy. So expedited removal, and this graph here is kind of presumes the border, a border apprehension. So somebody comes up to the border, they get primary inspection, secondary inspection, which means you probably have heard now about people coming to the airport being put into secondary. So if there are questions at length, primary is what you all go to when you come back from wherever. You hand in your passport. Secondary is being sent to another room for a longer interview. This is for non-citizens, by the way, but I mean you could be put in secondary as a citizen.
Steve, you want to
Yeah.
borrow this?
Huh?
Rather than using your hand.
Oh, sure.
It's the first one,
Thank
the
you.
one closest to the end.
Great. Awesome. So that's great. I like this. So but I need to be over here, right, Steve? No, I can't wander too far. Okay, so supervisory inspection then would be a supervisor saying, does this person have any right to be here? And then you can be removed immediately. Now pretend it's somebody who's here in the United States and is picked up by ICE. They go right into this part, detention, they get inspected, and then they can be removed pretty quickly if they're subject to what's called expedited removal. If they're not subject to it, they would go right down to here, discretionary parole or bond, master calendar, a bond hearing, a merits hearing, and all of this. So I'll explain this again in more detail in a moment, but that is basically the process right now. If you're seeing detention at the border, it goes this way, kind of straight down. If you're being detained, you go into detention, and you would have inspection and then potential removal.
If you were to have a family come in and
Yep.
experience this, is there a route that's usually like that occurs more often than the other? Like if it's
So
more
a
than
family
one?
who's coming in with or without, what in your hypothetical, is this
Without.
a family, so it's family that's, let's say, fleeing persecution. So what would typically happen is they get primary inspection, they'd be at the port of entry, let's say they're apprehended by CBP, they'd immediately go into secondary inspection, let's say they cross the border, let's say it's a mother, father, and 2 children. Typically, they would, let's say they're from Central America, they would probably have a fear of going back. Detention, the mother and the children would probably, if they're under 18, would be put at Carnes or Dilley in Texas or Berks in Pennsylvania. The father would be sent to a place like Polk or some other detention center. They would be separated that way, and then they would have independent credible fear interviews, which is, do they have a fear of returning? If they pass that interview, they go into the rest of what are called Section 240 proceedings. If they don't, they would then be subject to a review of the credible fear determination and then removed. So we'll discuss that again in a second. But I want to talk about expedited removal. Here, I'll let you hold this for a second. I want to talk about I want to talk to you about expedited removal because this is something that didn't get as much attention as the travel ban when it went into effect, but is really far-reaching and important. INA Section 235 allows expedited removal for any alien who has not previously been admitted or paroled into the United States. So admitted, again, meaning that they have actually been stamped, admitted, not EWE. And who has not affirmatively shown to the satisfaction of an immigration officer that the alien has been physically present in the United States continuously for the 2-year period immediately prior to apprehension. Now, prior administrations, going all the way back, at least the Obama and Bush administrations, I think this was in effect in Clinton too, applied Section 235 expedited removal only to aliens within 14 days of entry and 100 miles of the border. Those of you who've been near the border in Texas, you know that 100-mile marker. You may have seen it. They've got, they have CBP officers kind of stationed on the highways down there and actually do stop and screen people, looking for people who are subject to expedited removal. This administration has proposed, but they have not yet published in the Federal Register, but has said that they will expand expedited removal to the statutory maximum, which means anywhere in the United States, not just within 100 miles of the border, and anybody who had been here for 2 years, for less than 2 years continuously. And the most chilling part of this is this part here, and who has not affirmatively shown to the satisfaction of an immigration officer. So that doesn't give you a lawyer in a court to hear it. It just means the immigration officer can say, you don't seem like you were here for more than 2 years. I'm going to put you in expedited removal. And again, going back to that, expedited removal doesn't get you into court. It can get you sent out of the United States quite quickly. And that's one thing we have to kind of protect against when we talk about the raids and other things that are going on, is worried about people being picked up. Now, what can we do in that? One is making sure that if people do have a fear of return, that they are able to express that fear of return. And we'll talk about protection-based relief. Another is going through, is making sure you're able to prove that you've been here for more than 2 years, having a lease, having documents that you can easily point to very quickly to say, I have been here for more than 2 years.
Birth certificates
So
of children.
yeah, I mean, well, birth certificate if you're here.
Or birth certificates of children.
Of children, right, good point. Like birth certificates of your child. I delivered a child here, or I am the father of a child who was born 4 years ago. You know, whatever, that's a great point. So as lawyers, we can think creatively about what all those would be, but that is particularly important that folks are aware of this and know that they need to be able to prove with relative ease and speed that they have been here for more than 2 years.
But
Sue.
someone's picked up, and they don't have all that on them, what opportunity do they have to get those documents to be able to?
That's a good question, and it really depends on how quickly you can identify them in detention and how quickly they can get back to them. But I think a lot of it is education, and I certainly, to the extent I have clients who are out of status, I've advised them to carry some of that with them so that they actually have like a child's birth certificate or a lease or something that shows they've been here for more than 2 years, but also have my phone number ready to call. And do have like know to call in immigration legal services thing. In all the detention centers, they do have toll-free numbers, and they have calls that they're able to make to consulates, but also nonprofit immigration organizations. Obviously, those can be overwhelmed, so you don't want to just rely on those. One of the exceptions, again, is credible fear of persecution for asylum seekers. One of the clients at Carnes I use as an example, her name is Cindy. She and her daughter came up here fleeing one of the gangs called Barrio 18. She initially went through what's called a credible fear interview that has to show that she has a credible fear of persecution and significant likelihood of proving a claim for asylum, withholding of removal, or relief under the Convention Against Torture. Cindy actually failed her credible fear interview. In fact, this is somewhat of in a way, a great story and also a humbling story as a lawyer. Cindy was one of the first people I met at Carnes when I went there in September of 2014. And as we were triaging the cases, we looked at her case and it didn't seem to have any great indicia of relief. And so we said, you know, in all the cases we can take, and there were 500 plus women and children there, we probably can't take Cindy's case. And so, you know, I wrote down her information and then just, you know, we weren't going to follow up with her because we couldn't do anything. But she called me after she got the negative determination. She got scheduled for a hearing before a judge, and I got a call from her in my office in Washington. I got a translator on the phone, or a colleague who could translate for me. And she said, I have a hearing on Friday. This was either Tuesday or Wednesday in San Antonio. And I said, you know what, I'm going to be in San Antonio that day. I'm coming back to Carnes. And so, you know what, I don't think she's got a good case, but I'll go. And, you know, I've never done a negative credible fear review. It's actually not something a lot of lawyers do because it's not a part of the process we see a lot because of where it's conducted and everything else. So I went in and I did the hearing, and I convinced the judge that she had a claim under the Convention Against Torture. It was one of those where the judge said, okay. Like it was that. Just last week, we actually, her case, she ended up moving to, now I'm forgetting the name of the town in North Carolina. It starts with an L. Cute little town. Anyway, near Charlotte, not too far, like an hour away from Charlotte. And we had our immigration court hearing in Charlotte. We lost at the Board of Immigration Appeal. We appealed to the Fourth Circuit, and last week the Department of Justice called and said, we don't think we can defend the case. We're going to remand it back to the BIA for further review, which is a good development because even if we wanted the Fourth Circuit to be sent back. So it's a good story of kind of never giving up, although she was the one who never gave up. I was kind of ready to initially. But so what happens is you go to the immigration judge and you can basically prove that review, but that is right on the precipice. And in all the years I've been practicing, I've never done one of those, and that you feel it like you're right on the precipice. You are the one person between that family staying in the United States and leaving within a week. So it's great work if you can get there and do those credible fear interviews. So a positive determination, so what happened in Sydney's case, the judge said, oh, okay. She got put in what's called Section 240 immigration court removal proceedings, which are the proceedings that anybody who's not an expedited removal in immigration court goes into what we call 240 removal proceedings. And that is, when you think about it, it is the due process that we give immigrants before deporting them. So as opposed to expedited removal, which is not much due process, 240 we give them full court hearing and trial. And the way that starts is with what's called the NTA, the notice to appear. So think of that somewhat like the charging document in a criminal case or a complaint in a civil case. It's somewhere in between the two. It has both allegations and then charges. So the allegations, and this was one of the women from Carnes. You are not a citizen of the national United States, you're a native of El Salvador, you own the United States. On this date, you did not possess a valid visa, and you were not then admitted or paroled after inspection by an immigration officer. Those are pretty typical, and in a typical asylum case, you're going to be admitting to all those allegations. They are true. And you probably are admitting to the charge of removability as well, and then pleading affirmative relief. And we'll talk in a moment about kind of relief versus challenging. But this is the way the immigration court proceedings start at 240 proceedings. There are other technical immigration court proceedings that, frankly, I've never really encountered, so I'm not going to talk about them today, and I doubt any of you are likely to encounter them. So this then is the Section 240 removal proceedings. Go here. So once you've gotten out of that expedited removal box, again, you get that full panoply of court proceedings. So how it starts, the first thing that you have in and there aren't many things, which is one of the great things about practicing the immigration court, is you don't have tons of hearings. There are no discovery disputes, so you don't end up kind of going back and forth with the judge. You go to a master calendar. It's usually 2 or 3 weeks from the issuance of the NTA. You'll be scheduled for a master calendar. You can plead to the NTA charges. You can either contest them or concede them. In most of our cases, if you're doing asylum or protection, you are conceding the charges. They are just, you don't have a right to be here. Yes, I don't, but I want to apply for some sort of relief. But there are places where you may, and I'll talk about those in a moment, there are clients you may want to actually contest the charges of removability. The master calendar is a big cattle call. You're kind of sit there with all the other lawyers and family members. If it's detained, it may be done by video conference. If it's a non-detained docket, everybody's just sitting there, gets called up in series. You assert your claims for relief then. I want to apply for asylum or withholding of removal or a convention against torture, or something called cancellation of removal. I'll go over all of those. And then they set a date for a merits hearing, a bond hearing, sometimes a further master. If the client, if the respondent, who's the alien in that circumstance, is called a respondent in immigration court. If the respondent is not represented, they often will put over the master calendar for a couple weeks, give them a list of legal service providers, and hope they find a lawyer in the next couple weeks. If they do set a date for a merits hearing, which is a trial, a bench trial, it's usually about a 2 or 3 month wait for a detained, on the detained docket. On the non-detained docket, it's now 2 to 4 years or more. I have a client, and this shows you the backlog in the immigration courts, just over the last 20 years, but you can see the spike in the last few years. I had a client, for example, who applied for, he's a stateless Palestinian. He applied for relief at the asylum office for asylum, was denied asylum he applied in 2014, was denied in early 2015, was denied asylum, referred to the immigration court, and his master calendar, not his trial, his master calendar is in 2019 in Chicago. So he's got a 5-year wait. Now, luckily, he's not detained, so that's why it's a 5-year wait. If it wasn't, it would be quicker. He is able to work during that time. one of the rules is if you apply for asylum and there's no decision by an immigration court within 180 days, you get work authorization as long as you didn't cause a delay. So he can't work. The problem is, of course, is that he's in this limbo status. He has a wife and 2 children who are thankfully here with him. But his children, as they start to now get closer to college age, will not be eligible for any type of financial benefits, at least government-funded financial benefits, as they await their status. Yeah?
We are not that backed up in Charlotte.
Yes.
Between like detention and first master calendar is about 9 months right now, 9 months to a year.
Between trial, you mean, and master calendar?
No, between like, if I have a guy locally detained here who served with an NTA.
Yeah.
And before our first master calendar hearing gets scheduled in Charlotte, it's more or less 9 months right now.
Yes, that's an unusual one, is the 5 years.
Because of that, if I get people who come to me from Chicago or San Antonio or somewhere, and they want to, like, they're moving here, they want to change venue here, I'm like, bad idea.
Right.
Right. You're going to be in front of a judge within 9 months, and every one of our judges here is going to deny your asylum request.
Right.
And so, just for private lawyers, if you hear of people moving here, I'm like, no, live in Texas.
Yeah, that is a very good point. And it's, yeah, so there are courts that are certainly quicker, certainly where there's not a lot of detained docket. Those do move quicker. That's about probably the quickest right now in the country, because I know DC, the Arlington and Baltimore courts are backlogged. But one of the things, when you move, they don't necessarily move venue either, although they would probably move it to Charlotte given the backlog, given the lack of a backlog. But we've actually have had challenges sometimes even moving venue for some clients. So again, what you can do is you can contest removability. So those first allegations, some of them may not be true. The charges may not be true. That's particularly in the criminal context. So someone who's a legal permanent resident who is charged with removability under one of the criminal charges may say, well, this criminal charge does not qualify as what's called an aggravated felony, for example. And this is, you could do a whole day seminar on what's called criminal immigration law, and the intersection of the two. But that's an example where you would contest removability. You would say, no, my client actually, yes, he committed a crime, but that crime is not properly categorized as something that makes you lose LPR status, so we are contesting it. You may have a claim to citizenship. It's possible that they've actually, we do have clients on occasion that their parents became citizens before they turned 18, but they never actually bothered to get the certificate and didn't even realize they were a citizen. That happens sometimes. They could have a parent who they didn't even know was a citizen, and it occasionally does happen. But typically what we are litigating is the relief from removability. So typically it's, and that is one of the weird parts about it, is once you've done that, once you've conceded removability, the burden shifts back to you. So you're in this weird thing where essentially you're being prosecuted in immigration court, but you are kind of, all the burden is placed on you, and the burden of coming forward with evidence and everything else is placed on you if you are claiming relief from removability. The typical ones that we do, again, as pro bono lawyers, are the protection-based remedies. And these are, asylum is discretionary, but withholding removal is mandatory. But essentially, these are the remedies for people who fear harm if they go back to their home country. And let me talk about those briefly. Again, these are ones you could do a whole seminar on asylum and withholding. Asylum has a few key elements to it. One is it has to be one of 5 protected grounds in order to claim asylum. Now, typically you hear people use the term political asylum. That is just one of the grounds for asylum. There's nothing magic about political asylum, about asylum based on political grounds. It's just one of the grounds. So that is one, obviously kind of the paradigmatic one. Next is next is race, religion, nationality, which is also kind of ethnicity, clan, something like that. It's kind of broadly defined. And then, where a lot of litigation happens is what's called particular social group. Particular social group is basically, to put it succinctly, something that you cannot or should not be forced to change that is kind of innate to you. So gender has been found to be a particular social group. If you've heard of the cases of female genital mutilation, those are litigated under particular, or granted under a particular social group. Sexual orientation cases are particular social groups that have been for more than 20 years. It's not an emerging area of law and immigration, at least. It's recognized as a ground for asylum. Certain occupations, for example, I had a client from Iraq who was a professor, and professors were being targeted in Iraq as a class. It's kind of a class of intellectuals, and that was something she couldn't change. She could quit her job, but she could not change being either a professor or ex-professor or academic, or shouldn't have to. And so those can be seen as particular social groups. And another one that emerged, thankfully, just in time for the women and children who were coming up from Central America, a case called ARCG, which determined that women who were fleeing domestic violence and could not be protected by their home countries and could not leave the relationship safely qualify for asylum. So that was kind of capped off about a 20-year legal battle that goes all the way back to Janet Reno. So those are, particular social group is one. Yes?
Disability?
Disability would be one, would be a particular social group, sure. If you're, now again, then, and let me use that as an example. That's a great example. So let's say you've got a disability, and then you would have to prove that if you went back, that you would actually be persecuted on account of that disability, that the persecutor is kind of targeting you because of that, not just that they're ignoring you or not supporting you. And that is called the nexus. So there has to be a connection between the persecution and that ground. And so the way that the law is articulated, one central reason, not the only reason, but one central reason has to be on account of your political opinion, your particular social group, or something else. And then there has to be persecution, which is more than mere harassment. It can be past persecution, which puts you in this odd circumstance when you're representing a client and they tell you they've been tortured. You're like, yes, good, I've got good evidence here. It is kind of that weird thing where you're like, okay, that's a great case. But you also then have fear of future persecution. And ultimately that's what the law is looking at is this person in danger if they're returned home? If you have past persecution, there's a presumption of future persecution, although that presumption can be overcome if there's been a change in country conditions or something like that. And then there have to be, so once you've proven all of that, there have to then be no bars to asylum. And one of the critical bars, especially for people that have been here for a while, is the 1-year filing deadline. If you do not apply for asylum within 1 year of entering the United States, unless there's been changed country conditions or a change in your circumstances, like the government changed, now I'm in danger, or you've been in status. Let's say you were a student here for 4 years, you don't have to apply during those 4 years, you have to apply within a reasonable time period after your status expires. But the 1-year filing deadline is an important thing to keep in mind, but it's also important to keep in mind that it's not, that there are exceptions to it, and exceptions that actually do prevail. So we often hear people say, I've been here more than a year, I can't apply for asylum. That's not hard and fast true, but it's a deadline to be familiar with. Withholding of removal does not have an asylum can be, as we mentioned, can be granted at the asylum office, right? But none of these other protection-based remedies are granted at the asylum office, only asylum. Withholding of removal, it makes sense it's not granted at the asylum office because it is literally withholding the removal. What happens in that case, it is the exact same standard as asylum, except you have to prove the persecution is more likely than not. In asylum, your burden is proving I'm trying to remember how they articulate it, but essentially a reasonable likelihood of persecution, which has been defined at about 10% chance of persecution. So you actually can have these weird cases where you're eligible for asylum, but you didn't file within a year, but you're not eligible for withholding because your asylum case isn't more likely than not. I've actually seen cases like that. So withholding of removal is a mandatory remedy. If you qualify, you have to be granted it. And then the last one I want to discuss here in a little more detail because I do think it's an avenue that lawyers have not explored enough, and may very well be available to some of our clients who have been here for a long time and are from some of these countries like El Salvador and Guatemala and Honduras, which are particularly violent, is Convention Against Torture Relief. Convention Against Torture Relief, the one benefit to it is that it doesn't have any nexus requirement. It doesn't matter why you're going to be tortured. Just the fact of torture, if torture is more likely than not, you've satisfied one of the two elements. It doesn't matter whether, for whatever reason, you're going to be tortured. That's all you need, is that to satisfy element one. The element two, though, is more tricky. It has to be either by or at the acquiescence of the government. And acquiescence has been defined as essentially willful blindness of the government. So a lot of the litigation around the Central American cases we've done is about whether the government has essentially ceded control to the gangs enough that you can say they're turning a blind eye to what the gangs are doing to people. It doesn't have to be a blind eye to this person's torture specifically. It doesn't have to be the government says, I'm not protecting Cindy from persecution or from torture, but we just have to show that they essentially allow the gangs to do that.
Are there regimes that kind of automatically qualify? What I'm thinking of is North Korea.
Right, North Korea would probably automatically qualify if you are. Now you probably can get asylum if you are, but let's say you were a North Korean who was here and had no status for years for some reason. Yes, you could do that. The other one that's been successful for Mexicans are the gangs as well. There are a couple of very good Seventh Circuit cases by Judge Posner that have found that credible threats by the Zetas and some of the other gangs down there and that the government essentially is even complicit in those. And it doesn't have to be the government, meaning the presidency or the federal government. Could be local police who are essentially turning people over or collaborating with those gangs. So there actually is a fair amount of decent case law on this, and it may be the people in a community like in South Carolina who have been here for some time and may not be able to prove that they have a specific fear of going back based on their own conduct or based on their own status. They may actually have a Convention Against Torture claim. There are also some what I would call status-based remedies. One is if you have been here, it's called cancellation of removal. It's a discretionary remedy, but if you've been here for 10 years or more, even if you're entered without inspection or undocumented, you can qualify for what's called cancellation or removal if your removal would be a significant hardship on a U.S. citizen. So that can be, one area we've done that is for parents of disabled children. It can't just be my kid's a U.S. citizen and I don't want to leave. That's not a significant hardship. But we have shown if the child would be harmed. We had one case where it was a Japanese woman had married an African-American man. They had had a child together, and we were able to show that if the child went back to Japan, that child would be ostracized in Japan. And we were able to win on that claim and get her removal canceled on that basis. So there are ways that you can show harm to a U.S. citizen, and especially, again, if you have a particularly vulnerable child. Yes?
What if that person has already been removed and sent back to Jamaica? Is there any way you can get that person back?
You know, I don't know. I would say no because they've already been removed and that removal can't be canceled once they've been removed. But I wouldn't say that a creative lawyer couldn't somehow make it happen. But I don't know of anything that says to me right now that I could cancel a removal that's been executed already.
If you have a qualifying relative, there's a waiver for somebody that's been removed. But they have to have a U.S. citizen spouse or a 21-year-old kid or something. They have to have something. Right.
That's not canceling the removal, but that's getting them back in the U.S. in another way. Yeah, there may be other ways for them to get back and also they have to overcome the bar of once you're removed, you have a 10-year bar from entering the United States. So these are some of the status-based remedies. You can also have cancellation under the Violence Against Women Act if you have a client who's married to a U.S. citizen or permanent resident who has been abused physically, sexually, emotionally by that client. There are also, if you have pending applications with USCIS, the courts generally will essentially put your case on hold until USCIS adjudicates that. I say generally because it is a practice, not a requirement, and I don't know that DHS is going to be so generous in allowing USCIS to process applications. But generally, if you have an application pending to adjust status and everything else, you can potentially stay removal proceedings if you have other potential. So bond, as I mentioned, is particularly important for people who are detained. Again, anybody who has entered the United States is entitled to get a bond hearing as long as you've entered and you're not subject to mandatory detention. Yes?
I'm sorry, I wanted to ask something on the last page. You had
Yes,
mentioned
please.
application for crime victims.
Yes.
Is that for victims of crimes in the U.S.?
In the U.S.
Okay.
Yes.
And does it only allow them to remain in the country while prosecuting them?
No, it gives them a permanent it gives
status.
them it gives them like a 3-year status, and then they can apply for permanent residency.
Okay.
Yes, so those are called U visas, and those are for victims of certain crimes. There's a list of crimes. They're generally violent crimes, although there are some that are not necessarily violent, like witness tampering and things. There's some obscure crimes. Probably most people are not subject to witness tampering, but then it's required that you get a certification from the essentially law enforcement, although it could be the judicial official too, that you cooperated in the investigation. Doesn't mean that there's been a prosecution. It's not a witness visa. So don't confuse it with that. It's not that you have to be. There are different visas. I can't remember what the number is. I think it's S. I think it's an S visa that is for somebody who's actually a witness, that the DHS can actually get that visa and keep them here to testify. This is different. This is someone, and this actually is why, to kind of do a little bit of an aside, why federal policy is a little weird in the sense of when we pick up people who are in any places like in family court, we want, the U visa says we want people who are undocumented to come report crimes. We want to give them an avenue to do that. But then we have ICE on the other hand who's saying we're going to pick up anybody and deport anybody who's not here lawfully. And so then that's why a lot of police chiefs say, no, we like the U visa because we want to allow witnesses to come forward and we want to solve these crimes. And if we don't have that as a carrot, or essentially, and can't offer them protection if they come forward, then we're not going to be able to solve these crimes. And so that's a lot of the push and pull, and even within federal immigration policy, much less between the police chiefs and ICE. So bond is first set by ICE, determines bond first, says we're going to set bond, and either they set it high, or for the women in Carnes, they were actually claiming that they were national security threats because they were all flooding over the border. And that got set aside after a while. But ICE first sets the bond, and then bond gets reviewed by the judge. So it's actually a bond redetermination hearing, technically. So if you see the term bond redetermination hearing, it actually is because technically ICE sets the bond first, even if they don't set a bond. But they have to do that. So then you go to the judge and say, I want to redetermine it. There is something called, and I won't go into this detail, but in a lot of detail, but what's called a matter of Joseph hearing, which is a hearing about whether you're even entitled to bond. So you can actually challenge, first you can challenge whether or not DHS's categorization of you as subject to mandatory detention is proper, and then go to a bond hearing. So it's called a matter of Joseph hearing. And DHS has to show that it's substantially likely to prove its allegation that you are subject to mandatory detention. Bond is then redetermined by the immigration judges and proceedings. The minimum is $1,500. They can do own recognizance. We had a trafficking victim who was released on own recognizance, but that's unusual and requires really that level of kind of sympathy to have own recognizance release. Bonds are set for $15,000 to $25,000, and the one thing I will mention, this is incredible. When we were doing Karn, when we were working at Karns, we were actually working a lot in Washington with policymakers, and policymakers didn't even understand this in Washington, that immigrants are essentially paying 100% of that bond amount. It is not like a bail bondsman where you're going in and paying 10% down and then you lose the 10%, but as long as you make good on your bond and abide by the terms, they're going to pay that off and they'll keep whatever your 10%. If you're an immigrant, there's almost, and there may be some that finance it around, but there are not many. We were unable to find any. So immigrants are paying 100% of that. And I was in Washington, we were talking about bond amounts, and it occurred to me in these meetings with senior DHS officials, we were talking about bond policy, they're saying, well, $8,500 is not a lot for a Honduran woman. It's like, and we're like, yes, it is. It's $8,500, not $850. This is, you know, so Cindy, for example, this Honduran woman who had was no threat to anybody, the judge set bond at $8,500, and we essentially did a Kickstarter campaign and we're able to raise it for her, and through some charity got it. But essentially those are serious amounts of bond. So bond, it's not enough just to get bond. You also have to really be arguing the amount. So how do you do bond at the immigration court? Well, first of all, the bond standards do give a lot of discretion to the IJ. So you're really focusing on discretionary factors rather than really arguing kind of the contours of the law here. So first, is the client a flight risk? Well, if your client has been here for a while, you've got hopefully some history of them here in the United States, their community connections, and hopefully you can get what we call a sponsor. It's not a formal sponsor, so I should have put that in quotation marks. It's not somebody who is ultimately responsible for the person. If they're not putting up the bond themselves, they are not personally responsible for that person. But what they are saying is, in the case of Cindy's case, Lenore, that was the name of the town. I was trying to remember North Carolina where she went. When Cindy went to Lenore, her sponsor, basically said, I will house her, I have room for her and her child, I am a US citizen, and sent us the citizenship certificate. I know the family this way, I'm able to support the client because the client could work in that circumstance. And I'm willing to help the client appear for hearings. Basically, she'll get mail at my address, I'll tell her when the hearings are. So that's one thing we can get is from a sponsor. Obviously, people who have been here for some time has an advantage over somebody like Cindy because they have connections to the community. You want to prove they have a strong claim for relief, because if they have a strong claim for relief, that means they're more likely to show up at their hearing. One of the issues we actually litigated around Cindy's issue was the issue of how much you had to prove their strong claim for relief. Remember, Cindy had passed a credible fear interview before a judge. So our argument was a judge already found that she has significant likelihood of relief. And DHS wanted to essentially do a mini trial of her claim for relief. And my argument was, if a judge already told her that she has a significant claim for relief, she's going to show up. It's not about whether or not who has more evidence. It's about whether or not she's going to show up at this hearing and whether she thinks she has enough reason to show up. You can also articulate what the difficulties are for the person living in detention. So essentially, if they have medical issues or other issues, I won't go over this in great detail, but as you might imagine, medical care in detention is not first rate or even third rate. If the person has a lack of criminal record, and then their manner of entry as well into the United States. So if you have somebody, for example, who came here and overstayed a visa, that's going to be a more positive bond factor than somebody who entered the United States without inspection. So that's going to be a positive. And then, ultimately, one of the factors is flight risk. There are two factors, really, flight risk and threat to community or national security. Those are the two things they're looking at. Obviously, flight risk is typically the big one you want to focus on. If your client really has a criminal record, bond is going to be set pretty high, unfortunately, because the judges are going to are likely to find that they are a threat to the community if it's a typical judge. Now, the Section 240 bond proceedings are typically very short hearings. They are separate from the master calendar, and interestingly, they actually are considered a completely separate proceeding from the rest of the 240 proceeding. So any evidence you put in there gets put in a separate folder in a separate part of the proceeding, and does not bleed over into the merits proceeding. Not that they couldn't use it both ways, but you can't presume that when you've submitted evidence in bond that it is in the record. You have to resubmit it for the other part of the case. Again, it's obviously something you've submitted, so it can be used, but know that it is not formally part of the other part of the record, the merits record. It's just a good practice tip to remember. DHS will be represented by what's called the Office of Chief Counsel. That's within ICE. We call them trial attorneys or TAs or assistant chief counsels. What we typically submit is what we call the bond packet, which is a declaration and evidence of that sponsor in the U.S. A declaration, sometimes I say maybe, and other evidence from the client. It depends on, sometimes in this kind of proceeding, I probably would do a declaration for the client, but also obviously if you think the client's going to be subject to cross-examination, you may just want to have them testify. And then you have to, in that declaration, talk about all those things we talked about before. And then if there are documents that are in possession of ICE, make sure to request them from the Office of Chief Counsel. While there is not discovery in immigration court proceedings, so you can't issue a discovery request and get all that, you have to do a Freedom of Information Act request, which will take more time to get than you have before your bond hearing. But you can at least ask the Office of Chief Counsel to hand over some documents that are important for bond.
What kind of documents are you speaking of?
So sometimes those are identity documents they've taken.
Who've been submitted by the individual?
No,
to the ICE agent?
Right, to the ICE agent. The ICE agent has confiscated them. And some of those documents we talked about, they may be carried on them, could have been taken away as well. So anything that's been taken away from them. Now, typically in detention, they are allowed to have access to some documents, but not their identity documents. So typically it would be identity documents that you'd be asking for. The client may testify in the case. I've also had, in Cindy's case, I don't think she testified. We just had her declaration we submitted, and the judge took it under advisement, and we had kind of oral argument on that. So what you can do from afar, if you're, let's say, for example, there's somebody at Stewart in one of the projects that's going on there. There's the American Immigrant Representation Program that's going on there. Their Southern Poverty Law Center is working with them on a project at Stewart. One thing you could do is offer to help construct a bond packet. So let's say you have somebody who was taken from Colombia and is being detained in Stewart. Well, all the backup evidence for that bond packet is going to be here in Colombia. So you could help get declarations. You could show what their legal status. You could get the sponsor information we talked about. Gather declarations from the community, from pastors, community organizers, whoever else knows this person and can vouch for them. And I would even say, to the extent you are submitting it, put it on your, on your law firm letterhead or your own letterhead, and make sure that a judge understands that there's some lawyer in the community here who cares about this person, not just the person who's actually representing them. That can actually be kind of a compounding effect of saying to the judge, there's somebody from the outside looking at this process and who cares about this process, not just the lawyers who are practicing here in Stewart. And so all of these, you can essentially help that lawyer create this. And I'll tell you, it was a big benefit to us when we were working at Carnes, because we would spend most of our days at the detention center meeting with the clients. These detention centers do have typically relatively generous attorney visiting hours. 8 to 12 hours a day when you can visit with your client. And if you're representing a number of clients, you're going to spend 8 to 12 hours a day in a detention center. Most detention centers will not let you bring your phone, your computer, or anything else. At cards, we were allowed to bring in our computers at least, but we had to negotiate that over a period of weeks. And so you would expect, if you're going to a detention center, only to bring in pen and paper, so you're going to do it old school. And then when you get out of there, thinking about it's already 6, 8 o'clock at night, you've got other stuff to do. How are you going to get all this bond packet put together? So the lawyers working in these detention centers, whether it's Stewart or somewhere else, if they have either a client who's from South Carolina or a sponsor or somebody else who's going to help them out here, that would be of great benefit. And Baker Donaldson, a firm with a big presence around the South, was a big help to us in getting a lot of sponsor packets put together as we were working with these women and children at Carnes. So what is a merits hearing like? And it's funny, a lot of people call them hearings. I like to, as a litigator, refer them as trials because really they are trials. And I think especially for those of you who are looking for trial experience, these are trials. The one difference is you're unlikely to do much cross-examination because DHS typically is not putting up witnesses. It is less formal than state or federal court. The federal rules of evidence are guidance. The one key thing is that hearsay is admissible, regularly admissible. As you might imagine, especially if you're doing, let's say, an asylum case and somebody's talking about their torture or what happened back in their home country, those witnesses are not going to be available, and so that kind of hearsay is going to be, and you don't have to walk through all the hearsay exceptions to get it. They are perfectly willing to admit that evidence into the record, and even declarations from people here in the U.S. The immigration courts do not want to hear from multiple witnesses in a day. Typically, in an immigration court trial, I will put on 2, 3, 4 witnesses at most. My client, an expert on country conditions, sometimes an expert on PTSD or some other psychological or medical expert, and then maybe if there's somebody who's a recipient witness who happens to be here in the United States, then I'll put them on, but that's it. The federal rules of evidence then are accorded less weight, although one of my favorite stories from immigration court, I was litigating a case of a Sri Lankan man, and we were trying to, we had an expert who was testifying that he had, that he was going to be tortured if he went back. He had been taken hostage by the Tamil Tigers, a terrorist group, and he was Tamil himself. He had refused to cooperate with them, and so our expert had a lot of good evidence and had testimony that he was going to be identified as a Tamil, suspected of being a Tamil Tiger, and if they knew that he had been taken hostage by them, they would think that he was in fact a Tamil Tiger who would be tortured. And we had him rely on 2 declarations from human rights activists in Sri Lanka, who obviously weren't going to get testify. So we asked, as you would to an expert, what did you rely on upon reaching your opinion? Well, I relied on these declarations. Can you describe the declarations you relied on? Objection, hearsay. He said, actually, no, Your Honor, under Rule 702, this is an expert can rely on hearsay. And the judge said, the federal rules of evidence don't apply in immigration court. Wait a second, you just don't make up your own rules. I mean, but you're supposed to be more liberal, not more strict. But anyway, so it's a little unpredictable what the immigration courts will do. The one thing I would say is it's always better to kind of err. I mean, hearsay and the kind of general, getting declarations in really is going to be a problem generally. But obviously things like kind of your technical kind of examination skills, leading witnesses, asking compound questions, all the things that you really shouldn't do when the rules of evidence are just a practice. You should obviously in immigration court make sure that you're abiding by those rules. Submissions are due 15 days in advance of trial, and there's something, one resource I should have put up here is the Immigration Court Practice Manual, has all these rules in it. Typically we put in declarations, expert reports, country conditions reports. Again, under the rubric of hearsay, you can very regularly put in news reports, other types of what you would normally not put in a federal state trial of all sorts of types of third-party evidence. We always do a brief to the immigration court, keep it relatively short to the point. Obviously, there are, if there are certain issues you need to litigate, like is this a particular social group, focus on that, but you don't need 3 pages about the standard for persecution in there. The judges know that. So I would follow, again, that immigration judge bench book. DHS typically does not submit evidence or briefing at these hearings, which is different than a typical trial. Unless it is a case where you're adjudicating whether this is removability under some criminal statute, they will submit all the criminal records. So they will submit those typically. Occasionally I've had DHS call witnesses. It's happened, I think, twice in 20 years I've been doing these cases. Very unusual.
Criminal records include charging documents as opposed to convictions?
Yes, they do. And there's a whole criminal thing about how courts are not really allowed to rely on them, but it depends on whether there are omissions in them. It's a very complicated area, but yes, they can include charging documents. And if it depends on kind of which part of the statute they're alleging, whether it's a crime of moral turpitude or aggravated felony. It's a very complicated part of that, but yes, it could be charging documents. The one thing that is also very different in immigration court is that there's very little interaction with the DHS trial attorney before trial. Generally, you would say, I don't have to deal with opposing counsel. That sounds like a great deal. But it actually can be very frustrating. We had one case where we were using summer associates as part of their training to go down and litigate a case of a Burmese woman who had been tortured and raped down in her own country. It's a very strong case. When we went down, we had been calling the DHS trying to see what his position was. No return phone calls, nothing else. We show up in Harlingen, Texas. I flew from Washington. We have the lawyers come from Dallas. We sit down with the immigration judge. Great judge who was very nice. Oh, you have students coming. Who's going to do what? Does the student want to do the opening? It was great. Setting us up. 15 minutes he had us going back and forth and sitting down. Who was going to do it? He's orchestrating this whole thing. And he looks at the DHS attorney and says, okay, are you ready to start the hearing? He says, oh, we're not going to contest okay. Well, it would have been nice for he brought 5 people down to Harlingen, Texas, as lovely as Harlingen is during July. That can be the frustrating part. Now again, when you're walking out of there with your client who has just won asylum, you're not too bitter about it, but it is one of the frustrating things in this case, in immigration court litigation, is that it is very difficult to get DHS counsel even to interact with you beforehand. There aren't natural ways for it to happen because there's no discovery, there are no depositions, there's no kind of back and forth, and they also just don't have a culture of kind of interacting with opposing counsel. So often they won't even pick up your file till a day or two before the hearing anyway.
That's just rude.
Yeah, it is, and they really, the problem is, remember we went back to that backlog? That's one of the things I talked about before and I alluded to was the difference between you've got DOJ in the courts and DHS. You have DHS throwing all these cases into the courts, and they don't care that the courts are backlogged in the end. It's not their budget, it's not their agency. So you end up with all these cases backlogged and no mechanism for resolving those cases other than going to trial or, going to trial basically. There's no clean out. There's no, we've had a case of these Colombian nationals who were brought up here for their own protection by DHS because their relative had cooperated with U.S. law enforcement in a narcotics investigation. And now they're in removal proceedings, they're claiming asylum, and we can't even get DHS to really engage on the case. And it's been delayed for various weird immigration court reasons for years. And we said to DHS, let us bring in our client, and you can talk to our client. We'll do a proffer, essentially. So we don't do that. We don't talk to clients before hearings. So we just have to wait and do a whole hearing. There are 7 family members waiting for this to happen. So it can be very frustrating. On the other hand, it's nice not to have to deal with opposing counsel. You can ask for pre-hearing conferences, and in that guide I talked about getting off the assembly line. it talks about how to ask for pre-hearing conferences. There are pre-hearing conferences allowed in the rules, and a good immigration judge will at least take advantage of that and try to get DHS to narrow the case. Typically, in a trial, you're going to have an opening, which is a roadmap. It is not, because it's a bench trial, it's not a grandiose opening statement. But typically what we do is say, this is what we're going to do today, Your Honor. Here are the witnesses we did. And typically you're spending the first half an hour going, because you haven't had a pre-hearing conference, doing all the things you would do in a pre-hearing conference. Here are all the exhibits, here's what's going on, here's the claims, and then kind of trying to narrow it all down. Typically your client will testify first. Under the rules, your client has to testify in immigration court unless the other side stipulates, like in that Burmese case. You can move for telephonic testimony from experts and third-party witnesses. They are allowed to do that, but the court has to grant telephonic testimony. Declarations under 28 U.S.C. 1746 are admissible. They are ostensibly can be accorded less weight than live testimony, but I've never had a significant issue with that. Sometimes we do a client declaration, sometimes not. It really depends on the judge and the client. Obviously, if you have a client who you don't feel is going to be very comfortable on the stand, you don't want to give DHS ammunition for cross-examination. And then our witnesses, family members, acquaintances to the story. Sometimes, especially if you have somebody, if you're doing an asylum case of somebody who is, from a foreign country and has no way of proving who they are, just having somebody, I once had a witness in, he was from Cameroon, and we had another witness come and just say, oh yeah, I'm here, I'm a US, permanent resident now, and my family knows his family going back for a year, for a generation. And that was enough just for the judge to say, okay, this person is who they are saying who they are. That could be some of the biggest obstacles in immigration. And there are all sorts of other witnesses, obviously, you can bring. So how can you help from afar if you're not going to go to Charlotte or you're not going to go to Stewart? Same thing as you would with the bond package. You can help get the declarations from people. You can work with expert witnesses, helping to prep their reports. That can often be a very interesting and rewarding experience. Getting U.S.-based friends, an employer, a pastor, if the person has been here in the U.S. Before. Drafting the legal briefs, obviously that can be done from anywhere. At our firm, I've had associates in London and Geneva work on U.S.-based asylum cases, drafting legal briefs. If a witness is testifying telephonically, so if you have somebody here in South Carolina who's going to testify, representing that witness, again, just in a way of kind of sending that message to the judge that there's yet another lawyer who's interested in this case and cares enough about it, can be powerful. So what happens in an immigration court decision? Decisions sometimes come right from the bench, sometimes they're taken under advisement. Often if the judge is going to grant the case, the judge will ask DHS to waive appeal. Then the judge doesn't have to issue a formal decision, because if DHS waives appeal, you're not going to appeal, and that would be the end of it. So a victory for the immigrant could be a denied claim of removability. So sorry, DHS, you don't get to remove this person. That's it. They go back to whatever status they had. They can be granted relief from removal for all those various reasons. DHS can appeal to the Board of Immigration Appeals. They're allowed to do that. And they are allowed to detain pending appeal. Pending appeal to the Board of Immigration Appeals. Although I would strongly recommend going back for bond if you have not had success on bond or want to lower the bond. Because remember, one of the factors is likelihood of success. If you've just won at the immigration court, the immigration judge thinks you have a good likelihood of success. If removal is ordered, the respondent can appeal to the BIA within 30 days, and the removal order does not become final then. It is automatically stayed at the BIA. The BIA then has a paper-only appeal. It almost never grants oral argument. It may have less than 5 a year oral arguments. It's not that kind of body. And it typically decides appeals 5 to 7 months after the IJ decision is the typical, what we typically see. I've seen it happen quicker on some cases. I've seen it happen much longer. It just depends. Typically, you'll appeal within the 30 days to appeal is just a pretty pro forma notice of appeal that they ask you to articulate the reasons, but you're not really bound to those reasons very strongly, and you can write them broadly enough to protect all your rights to appeal. They will then generate the record. The record in immigration court there's no court reporter. It's done by digital audio, and then it's transcribed only if there's an appeal. So it gets then transcribed, sent to you in a big packet of the immigration court record, and then they give you a briefing schedule, which is 45 days from the day they send you the record, with one 30-day extension granted basically as of right. So you have that, and if your client is detained, the DHS and respondent appeals are due on the same day, and there are no reply briefs. So it's kind of a weird thing where you're essentially both writing your appeal at the same time. Now, if the BIA denies appeal, the appeal goes, again, we talked about, to the circuit court, the federal circuit court where the immigration court sits. So in Atlanta would be the 11th Circuit. DHS cannot appeal a negative BIA decision. I guess it can technically ask the Attorney General to review it. But when you think about it, they can't appeal because it is an agency, it's a federal government decision. It would be the federal government essentially appealing its own decision, right? So as a matter of agency law, that's why they're not appealing up to the circuit court. You can appeal up to the circuit court. Within 30 days, you file what's called a petition for review of the agency action, and you have to file a request for stay of removal pending appeal. Once that BIA decision is entered, especially if you have a detained client, removal will start. The process of getting travel documents and everything else could start, and your client could be removed within a month of that BIA decision. Especially if they just want to get somebody out of detention, stop paying for the detention, they will get them out relatively quickly. We actually have one woman in Carnes who was in line to get on the plane, and we got a stay of removal and got her off the plane, and she was granted asylum last month. But you need to be very aggressive on your request for stay pending appeal.
Sounds like you ought to request it a lot sooner than 30 days.
Yes. So you should file it as soon as you can. And again, the petition for review is pretty pro forma to the appellate courts too. Then they do a briefing schedule, so you can. Now again, if you're asking for a stay pending appeal, though, one of the factors is likelihood of success on the merits. So you need to actually brief that pretty heavily if you're doing that. So again, the process here, all the way down to the U.S. Courts of Appeal, and that's our 235 and 240 proceedings. So let me stop there, since I'm at the end of the presentation and almost done. For any questions or thoughts, folks have? Yeah.
If this happens, folks at the university, what if someone who has their papers, like a green card or, a visa that's appropriate, goes back to China, say, and they get detained there, the government says you can't come back for whatever reason. How can that be handled? I mean, what do you talk to about that? It's not.
So the government of China is detaining?
No. The U.S. says you cannot come back. I've seen this happen a couple times, and I'm assuming that the university handles this. I was just wondering what happens.
That's difficult because that is not as much. That's more of a State Department issue at that point than a DHS issue, and there's no. So what I would say is the university needs to handle it through their University International Programs Office. Typically, that's the way that they do it, is with the international students.
Well, who makes a decision like that? I mean, it happens?
It depends on what the decision is made, whether they violated their visa. You know, once you're out of the country, you have very little rights to come back in.
Yeah, that's the thing. I mean, they could lose their job and they miss semesters of teaching and research and all that. And I just always wonder, it seems like once you're out, you have no power to get back in.
What you do, if you are a legal permanent resident, if you do have a green card, under the travel ban litigation, they did find that LPRs had a right to a hearing before being denied
Where is that?
re-entry.
I wonder.
Huh?
Where would that?
I think they actually have to sue somewhere here. They'd have to find a lawyer to sue somewhere here in the United States and get them back in. But that was part of the suits that.
This happened a couple of years before all that.
Yeah.
It's been going on. So.
Yeah, it's very different. I mean, I will say one of the hardest parts about doing any sort of immigration law is the what goes on outside the United States or even at the border, because it's so opaque. There are not great procedures, even when, and I participated in some of the work at Dulles Airport when the travel ban was first instituted. I ironically had a client from Syria who happened to be traveling to Turkey when the travel ban went into effect. And so I had a client, I had to go to Dulles to figure out what to do. And it's not a place that we practice really, as you probably know, as at airports. And you can't get back to see the DHS people, so it was more just trying to, like, I was texting with him when he landed, and then was going back and forth with him on messaging and try to make sure that he got out, and he did. And then I was calling DHS personnel at headquarters that I had some contact information for. So a lot of it is just, I would say, advocacy rather than litigation for part of that. But and then obviously using the schools to advocate for their rights.
Yeah, I just wondered what happened because I see the person came back after a semester.
Yeah.
And who knows what happened?
Right. It is it's again, one of the harder parts is figuring out what's not in the U.S. Any other questions? Great. Well, thank you all so much.
Are you familiar with things that may come up? And don't worry, it's going to sound a little overwhelming, but it's just things that we're trying to get the parents to think about. And we're actually going to be screening the parents who are going to be coming to the clinic in our office. So we're going to be going over these things with them, but also the checklist we're going to provide you at the clinics. You'll be prompted to ask some of these questions to get the parents thinking about pre-planning for deportation and some of the documents they need. It's important that if the parents are trying to get documents for their children, especially if they're trying to get certain things from their consulates or trying to get U.S. passports, they have to have some type of identification too. And, it doesn't have to be U.S. identification because we're probably going to be we're dealing with parents that have status. In South Carolina, you cannot get a South Carolina driver's license or identification card unless you have status. So, the parents can go to their consulate here in the United States. The Mexican consulate that we use is in Raleigh, and they are excellent to deal with. They have helped me out on a number of Mexican nationals. Once you set up an appointment with them, Angie and I actually had a case with a young lady. We had her passport in about 3 hours.
Huh.
So you can't do that in the United States. But we went to the Mexican consulate, we submitted everything they needed in advance, went to the Mexitel appointment number, went and showed up, had the passport in 3 hours. The other consulates that we anticipate dealing with are El Salvador, Guatemala, and Honduras. They are all in Atlanta. We will give a resource packet to the clients with their consulate information and also a resource list for you. Will be in the packet, so you know that. If when we do the screening, we find we have other consulates that might be involved, we'll include those. But we're mostly including, thinking that we're going to deal with Mexican and Northern Triangle countries. So that'll kind of help you out. And The other thing we are reminding parents to do is have someone listed at the school as the emergency contact to pick that kid up. Because if they're deported and no one shows up, DSS has to call, the school has to call DSS. Can't leave the kid alone. So we're telling them to make sure it's someone who has valid identification because of lobby guard. And lobby guard is simply to make sure you're not a sex offender when you come to the school. When I've gone and spoken to high school students who might qualify for certain things, I'm proud to say I'm always asked for my ID, which I think if they flag me, hopefully they flag everybody unless I'm like the white token. But they won't let me in the school until they check me to see if I'm a sex offender. So, and a lot of parents call and complain about that. It's not because they're being pointed at, singled out. It's simply to make sure they're not a sex offender. And if for some reason the person doesn't have valid identification, typically what the school will do is have them wait in the office and someone will come and talk to them, but they may not be allowed in the school to protect the children. But we're telling the parents, hey, make sure you got somebody with valid ID that can pick up your kid. Make sure they're listed on your school paperwork. And, preferably have it be someone who is not at risk for deportation, if you can make that happen. And then we're also telling them, which Jennifer and Jim will get more into, it might even be good if it's the intended agent for the power of attorney. So that way they already have the kids. So that's something that we're telling the parents about, and they may even ask you about that too, so that's why we're kind of going over this. And the children are going to need a lot of things. Their birth certificates, their double nationality, if that's applicable. They could be a U.S. citizen and also be able to get Mexican citizenship or Guatemalan citizenship. Passports for all the countries they might be citizens of. The U.S. citizens of Social Security numbers. In some places, I know from working with the Mexican consulate for a long time now, that if you are trying to bring your U.S.-born child in, but they can also be a dual citizen, sometimes if you don't have that dual citizenship done, it will impact their rights in Mexico, even though they're of Mexican heritage. Even simple things like enrolling in school, sometimes. So the parents really need to make sure they're working on all this and doing all this. And believe me, the consulates, at least especially the Mexican consulate, they have all this on their website in Spanish. They come, every time they come to do visits, which it's usually typically only, unfortunately, the Mexican consulate that comes, but they come frequently, and their calendar is actually on their website. They go over all this with the parents to let them know what to do. The consulates are really strict with birth certificates, and it may be the parents actually need to go and get their birth certificates amended if they're U.S.-born kids. It's our understanding from talking to various staff, and Jennifer, correct me if I'm wrong, but we talked to staff last week at Legal Services and Managing Attorneys. They said if the birth certificate needs fixed, it's a U.S.-born child, we can send them to Legal Services to get that amended, or if they have to go to family court and get it amended, they can go there. But they really need to mention why, and SCLS does have Spanish speakers on the intake line, why they need the birth certificate amended. It could be, I'm trying to get my kid double nationality and the Mexican consulate wants it to have both last names. It could be this last name is spelled wrong and it doesn't match the passport the Mexican consulate will give me and I need it fixed to get this done. But they need to say why, because that could cause issues. If the child is foreign-born, parents are going to have to work with the consulate and follow whatever rules that country may have. Many times the consulate likes all last names of parents and children. I've been taking, just because I enjoy it, advanced Spanish classes for years. My Colombian professor went through this with his U.S.-born child here, where he dropped his second last name just to make it more convenient for English speakers. And they only put one last name on the child's birth certificate. When they went to go get his son's double nationality from Colombia in Atlanta, they made him go and amend the birth certificate that's U.S. born and put the second last name on. So it's not uncommon that countries want this. And again, if you start running into issues, what we're telling them to do, and if they ask you, is US born again, you can refer them to legal services for birth certificate amendments. If foreign born, they're gonna have to work with their consulate. But this is something that comes up frequently. We see it a lot. I get a lot of calls on birth certificate problems. And this is to give you some background of what some of the errors might be. Sometimes the woman will say one thing at the hospital about who the father is, go down to DHEC and tell them something else. DHEC will tell you they are not the trier of fact, and you got to go to family court and fix it if you told the hospital one thing and them another thing. They're very strict. So that's an issue. It's always last names are misspelled, Z or an S, one last name added instead of both. So it's just a plethora of issues that come up. And DHEC does have Spanish speakers, so that's not a problem. When they go and have to deal with DHEC and are trying to fix it on their own beforehand, DHEC will take any valid national foreign identification. They have a whole book of international ID. I've seen the book. It is extensive. It even goes down to different places like, well, this is the region of Mexico and what their driver's license looks like. This is the region of Mexico and what this looks like. I've seen the book. It is extensive. So as long as they have the valid identification, DHEC will not fight them on that. Again, I spoke about if you're referring someone to legal services, and we'll also have this in Spanish for the families. And the child U.S. born, they really need to explain why, when they call legal aids intake line, they need that U.S. born child's birth certificate amended. It's going to come down to double nationality. It's going to come down to getting your child's passport and facing issues, but that's very important. And this is all dealing with pre-planning. Even if they have U.S. born kids, they can take their kids back to their country if they want to. Or they can leave their kids here. But it's good to have all the documents lined up in case, you know, they're thinking about what to do, or some families may want their children to finish out the school year here, and then whoever their agent's going to be on their power of attorney to bring the kids down, or to put them on a plane. So the families need to think through all this, and they really need to think through too, if my child's not U.S. born, you know, they have the same thing. They can leave them here, leave them with somebody they know. But it's all about pre-planning, and when we do the intake, we're going to talk to them about what a power of attorney is, what it means, and to think through all these things in advance before they actually get to the clinic and see you guys. So they'll know some of this already. For U.S. born passports and most other places, most other countries, both parents have to approve the passport, and it's because of international kidnapping laws. They don't want one parent who's mad at the other parent going through a divorce to run off with the kid to some country that may not have extradition issues. So if one parent is missing, is there a death certificate? Is there a court order stating the other person's not required to give permission? Is there a way to get the other parent to sign off who may not be around? There's a special document that they have for U.S. passports that the other parent can sign. And we'll have that in your packet of materials, so don't worry about that. We also have that in Spanish to explain to the parents. And when we do intake, we're actually going to ask the parents, is the biological parent or adoptive parent able to sign off on this? If not, do you know how to find this other parent so that you can get your child's passports?
They also have a form, if you cannot locate them.
Correct.
You just show the efforts that you have made to try to locate them as well.
That's good enough for all of you. I don't know if everyone can hear him. He said there's a form that you can fill out to show you made good efforts and can locate the other parent. It's a good point. For the consulates, if you're trying to get the foreign passport, you'll have to deal with them on the laws and what their laws may be. For a child I was representing, his parents would not give me permission to get her passport because their rights were being terminated. The consulate, we had to take a court order And also, they only gave it to me temporarily, which I didn't care. I was just trying to get her into an immigration appointment to get fingerprinted and then get her interview for her green card. So I was like, I don't care if it's temporary, it's what I need for right now. So sometimes the consulates have different rules on that. And that's what it's talking about. And again, you know, these are all so that if the parents plan to go back, if they're thinking about taking their child back and they have U.S. documents like birth certificates, it's best to go get a special stamp from the Secretary of State's office on the documents that indicate the documents are valid and legitimate. Otherwise, the country they're going to may question if they're for real. We've seen this with school records, hospital records, birth certificates, and they can do that at the Secretary of State's office. There's also, you know, they may want to think about what airline would I be flying my kid back on. They need to know what the airline rules are about someone putting my kid on a plane. Yes.
Which Secretary of State?
Right here in South Carolina.
South Carolina Secretary of State.
Right. For South Carolina documents, correct.
Okay.
Oh.
Do you, for instance, if you have a certificate or something, do you take a certified copy and then just have them examine and stamp it? Do you carry it to them or have them?
Typically, people take it to the Secretary of State and they stamp it.
So I get the documents together, collect them, carry the packet to them, and that's what I was doing.
You could do that, yeah. They also have, and the Mexican consulate for their documents is also recommending people getting those stamped if they think they might be going to a third country, perhaps. Not going back to their own country, to somewhere else they consider safe. Yeah, Jack.
Is anybody in South Carolina not accepting a matricular consular?
Not that I'm aware of. They keep trying to pass. It's matricular consular card is just simply an ID from the Mexican government that says you're Mexican. It doesn't do anything else. Some places will let you open a bank with it, things of that nature. To my knowledge, people are taking those. We know of schools that have taken them for lobby guard to make sure they're not sex offenders. So to my knowledge, they're acceptable.
The post office won't accept them for issuance of a passport. You have to have a passport
Yeah, well, they,
or a valid South Carolina ID.
so hopefully they could take the foreign passport, because it is an official government document too. Yeah. So the matricular, that's all it shows. Yeah, it's good to know. And this next thing is just to give you some background on, parents may ask this, and we're going to put this in their packet in Spanish, but in case they get to this point and they're really worried, what will happen if DSS actually gets my kid? Well, there's some procedures that DSS is supposed to follow, and if they're not following, I need to know. Here's the worst case. Kid ends up in DSS custody. DSS will do an intake and try to determine if there are any language barriers and determine the child's legal status. And that's not to discriminate against them, it's just for service purposes and trying to figure out what their job is. If they don't know or can't figure out the kid's legal status, they'll just simply check a box, citizen of another country. They can amend it later. And the reason it is important to know that is, if the child is not U.S. born, or then they have to notify the child's consulate. And that's a good way that the consulate will also try to reach out to the parents if they can find them. So that's important to know, that they do have to notify the consulate for foreign-born children. They have to do that on a special form. Angie and I have had a case where they had to do this. And I will tell you, the Mexican consulate got very involved with that case, once they got notice. I had a lot of calls with them, even though I was representing the child. And then they have to make sure the Office of General Counsel knows about this. And so that is supposed to happen. If it's not, let me know, because I've been working with the General Counsel's office on this to make sure parents get notice and the consulate gets notice. That's just a backup to make sure people's rights are not violated. And then they'll have a staffing. Again, if they can't figure out the child's immigration status, that's fine. But one of the reasons that DSS will have the staffing is they actually, at least Dennis Gilmore, who's at the state office, takes it very seriously if he knows a kid doesn't have status, and will try to see if they qualify for any special visas like special immigrant juvenile status, or a U, or a T, or something like that. If it's flagged and Dennis sees it and he thinks the child could lose status because they're about to expire, then Dennis will help with that. They'll try to figure out other service or process issues. Do we know where the parents are? Can we find them to give them notice that we have their kid? Do we need home studies in other countries if the parents have already been deported? You know, they'll look into all those options. If the child is in deportation proceedings for some reason, they will work to get that child an immigration attorney to help with that matter. So those are all things that DSS is supposed to be doing. And I've had mixed reviews on that. I know with the issues I worked with them on or consulted with them on, they do follow this. And it could be because they know they're going to call me and I'm going to ask them if they did this, that they make sure before they call me they can check all these boxes off. So that's just some things to know, so that the parents know they do have rights. They should get notice. They shouldn't just be left out there having their rights terminated just because they can't make a hearing. They are required to serve the parents and to try to do the best of their ability to find them. The consulate is excellent for helping to find parents and relatives in the foreign country. If that parent has any identification from their foreign country, the consulate can easily track them. The Mexican consulate can especially really track them and are excellent at doing home studies in the foreign country. So the consulate can be very handy for making sure that parents know, work with your consulate. They're not the enemy. They can do a lot of things for you and assist you. So make sure they know who you are. Make sure you have documentation from them and they can help you find your kid, make sure your rights are protected. This is important to know, and it's something we'll have in Spanish for the parents. And to my knowledge, the current administration has not been away with this. If a parent is put in detention and they say, hey, my kid is in DSS custody, or I have an ongoing custody case, immigration is supposed to do the following. Place the person, the parent, in a detention facility as close to the family court as possible. If they can, help to set up visits and possible help with court appearance or some type of video conferencing for the court hearings. Help to coordinate with travel of the minor children and things of this nature. I have seen this work. I know of several cases that DSS has had where the parents have been sent over to Atlanta and spoken up and said, my kid's in DSS. What they've done with those parents is they've not suspended the hearing, but they put them all on electronic monitoring until that case is over and given them a chance to go to all the hearings and protect their rights and figure out the next steps. So I do know if the parents speak up, at least the last cases I heard of were under prior administration, but this wasn't working and happening. Parents just have to speak up because immigration doesn't know that the case is ongoing, but I've seen this work more than once. And we are educating the parents on that. And I think what I'm going to do, and this is just, you know, we'll have this in the parents' packet, in your packet, like who to contact if they're arrested in Atlanta and sitting out there. If they're shipped to some other detention facility, we'd have to look up that separately. But so far this has worked. We've seen DSS caseworkers work with this to make sure that the parents get notice, the parents get out on electronic monitoring, and we've seen it be very beneficial to the point that one dad was able, he was the good parent, if you will, the mama was the bad actor parent, and he was actually able to get out on electronic monitoring. The daughter had suffered serious abuse at the hands of her mother and her stepfather and was eligible for a U visa and could petition for her father's status also. And so it actually saved him from getting deported. So it does work. I'm going to stop here because I'm going to talk about the pro bono clinics at the end. Does anyone have any questions about what I just went over? Well, I would will be here if anyone thinks anything. And I am going to turn this over to Jim Harrison, who is going to be speaking to us about powers of attorney in dealing with property and financial issues that will arise.
What I'm going to be generally talking about is the people left behind, so to speak. You know, the families and so forth. That's a big area in itself, and some of the specific things I'll be talking about are seminars in themselves, and I'll only touch on them. I really see here in this conversation that there are really many different type of attorneys will be possibly involved in immigration, and both private attorneys and public attorneys such as legal aid. So how to put all that together, I'm not sure. I guess we just need to think about it. One of the things that I would be talking about as far as private attorneys, and I think this extends also to government attorneys, is at what point in time do you encounter the immigrant? Do you encounter the immigrant at a point in time when you have an opportunity to do some planning? Or do you encounter them at the point of time of crisis? And so I'll be thinking about that, and so my remarks will kind of be sort of, here are some things to think about if you have time to plan, and then here are some of the crisis things. And some of the crisis things will be exactly you have encountered as attorneys, what you would do normally to protect the client and yourself. I am chair of the circuit for fee disputes for the South Carolina bar. And so I see a whole lot of ways that lawyers get into trouble for not doing simple things such as documenting. So before deportation or other action, or when you have time to plan, and after arrest or at some other time of crisis, what I'm going to talk about, I would suggest to you, if you're going to be kind of involved in this area, if you're going to be involved, it's not kind of involved in this area. I don't think you're kind of involved in this area from what I have heard today. That you prepare for both. You know, if you don't have the forms that we're going to be talking about here today, get some in your computer. Get the contact people who you need to contact, the lawyers you will need to contact for a particular situation, bankruptcy lawyers maybe, you know, my law partner who is an expert in defense area, foreclosures and other kinds of things, and of course Appleseed in legal aid. If you're a private lawyer, when you first encounter a client or potential client, I would get whatever your agreement is in writing. Don't forget it in writing. Even if it's going to be a pro bono setting, even if it's going to be pro bono, you put that in your agreement. Have an agreement already prepared on your machine among your other attorney retainer agreements that deals particularly with this area. And you can outline it and fill it in as necessary. I would keep my time. I tell you that from a chair of fee disputes for the Fifth Circuit. I would keep my time on a timesheet. Even though you've got the best motivations, somebody down the road might see it another way. And so you are an attorney, you're sworn to uphold the profession, and we have standards. And we have these standards whether you're giving your services away or whether they're being paid for. So remember that. I would encourage, Tammy was just talking about planning. I would encourage when you encounter these folks to do a plan, write down a plan. Now I know that you perhaps are going to be dealing with unsophisticated people who are not used to planning, who are not used to, you know, living from this day to the next. But try to encourage planning, writing things down, where the documents are, who you need to go see, lawyer aid or whoever else. Encourage selection of a lawyer. Come back to me, come back to someone else. Here's a lawyer you would need if you get foreclosed on. Here's a lawyer you need to talk to, or several lawyers if you're going to be specifically talking about immigration. Okay, so I said to you we were talking about how to plan if you've got some time to plan. Here's some of the issues that I think that you might be facing, that families might be facing. And I realize that Perhaps most of these folks are not going to be on a scale where they're going to be having mortgages with Bank of America and things like that. And so I realize that. But I would plan for foreclosures. I would plan for deeds, even though perhaps you might not be seeing a lot of deeds or land held. I would plan for deeds. If they have deeds, how are they holding this deed? Maybe we think about changing the deed to be a deed with a joint with rights of survivorship provision, maybe to the spouse or to whomever. So maybe if there are deeds, think about the way they are holding title. Remember that if there is a mortgage, some people say that, well, can you convey the interest to the spouse without invoking the due on sale or due on transfer clause in the mortgage? Yes, you can, and a federal statute protects that. It's 12 U.S.C. section 1701J 3D 5 and 6. So there's a federal statute that particularly protects transfers between spouses. It does not invoke a due on sale clause. If you're dealing, it probably going to be seeing leases rather than deeds. How's the lease being held? Is it in the risk person's name, or is it in the spouse or other significant other? Maybe you should think about getting the lease changed to the person who's not at risk, because a landlord very well may just evict whenever a deportation proceeding or other type of proceeding. So think about the leases that they may have. Installment sales agreements. We see in our plaintiffs' practice, representing some plaintiffs, in certain parts of the state, many Hispanic surname customers. One of the things that installment sales agreements are named or called in the cases is the poor man's mortgage. Okay, the way an installment sales contract works generally is the seller remains entitled until the buyer pays off the contract, long time down the road. There are some rights that buyer has. Because of the language in most of these installment sales contracts, they have probably waived some rights of equity. But the South Carolina Supreme Court, in the case that many of you are familiar with, Lewis versus a premium investment, declared that there was a right of redemption by the buyer in an installment sales contract. So if you run into that and someone has got an instrument that purports to just kick the person out, there are some rights that the person has, and they are pretty clearly defined in our law now. What do you want to do with that installment sales contract if you can? And if it's just in the person at risk's name, since they're not deeds and you don't convey the deed interest to the spouse or change it to a joint with rights of survivorship type of interest, the way that you would have to transfer a installment sales contract is assign the contract. What you might do, and you're the buyer and you're assigning your rights to someone else, a spouse or something. Now, of course, that has to be agreed to by the seller, but normally I would think that sellers probably wouldn't have a great problem with it. So if you're dealing with an installment sales contract, think about the way that those can be transferred is by way of assignment, not by way of deed. Mobile homes, some people are so mobile home land sale packages. Some of these things we see, they're land out here, and the land may be in one name and the mobile home's in another name, and the mobile home has got one set of Vanderbilt mortgage, or somebody else has got the mortgage on the mobile home, where the land has got another set of obligations, and so that can get it confusing. I won't get into that law, but the law general mobile homes and whether it's a fixture just like a stick-built house, or mostly bankruptcy cases. And bankruptcy cases, have this transmutation of personal property to real property concepts. And we won't get into that. I don't think you'll need to. I just mentioned it, that there are myriad problems with mobile homes. I mentioned leases, bank accounts, debit cards. Gee, they ought to be joint accounts. But you say, I'm not sure that I'm really confident about this person over here being on the joint bank account. So I guess that you would have to consider what trust there is in that relationship. But certainly in joint bank accounts, if a person dies or if a person is not there, the person who is joint with rights to survivorship again, which is a law in South Carolina on joint bank accounts, you write the checks, has access to the accounts, and that sort of thing. So think about how the bank accounts, debit cards, checking and saving accounts are, and maybe encourage joint account type situations. Utilities. Think about the utilities. If they're in deportee's name, and the SC and G, whoever it is, comes around, they might not be willing to deal with you, spouse or significant other, whatever. Cable TV, those kinds of things. So think about, or maybe in your planning and talking about what you would do about those things that suddenly, the person in whose name these things were in were not there. Credit cards. I don't know what to say about credit cards. Everybody has them. They're in, multiple names, phony names. They're in all kinds of names, I suppose. But, the credit card companies are not going to talk to you, I guess, if you're not on the account. So you can think about what you might do. Healthcare powers of attorney, and in South Carolina, right to die, what is it? You all know, I wrote it down. Yeah, they call it a living will, but the statute they call it a living will. It says
but it's dying.
Right to die, something.
Desire to die a natural death.
Right to die a natural death, yeah. Prepare it, yeah. So those are two forms, and they're statutory forms. All you got to do is go to the statute, pull them out, put them in your computer. That's where they are. Y'all all know that. So be thinking about the use of those. I always do in a package when I do a will, I generally powers of attorney too. Some people say, no, I don't want a power of attorney. I don't want to do a desire to die a natural death. I don't want a health care power of attorney. And some people even think that general powers of attorney work for that health care power of attorney. No, hospitals are going to be looking for that. South Carolina health care. So think about those forms. Okay. Financial powers of attorney. Now I was going to go into some detail about that because South Carolina law changed on January the 1st. And guess what? I really think Sue Berkowitz might have been back there drawing the statute because some of the changes actually benefit what we're doing. It's just amazing. So I'll point those out to you. Generally, powers of attorney are in 62-8. 104 did this significant change. In South Carolina, it used to be when you drew a power of attorney, if you were going to make it durable, you said it was durable, or it wasn't. Now South Carolina, drawn after January 1st, it is durable unless it says it's not durable. Yeah, you didn't know that, did you? January the 1st. Also what it did, what is durable? Durable means not terminated by principal's incapacity. Now I'm going to surprise you with what incapacity means here. Always it blew me away when I saw this. I said, wow, eureka, incapacity. I thought that was, you had dementia or you had a physical ailment that didn't allow you to handle your affairs. Well, okay, let me mention 628106, validity of the power of attorney. I don't want to get too far in this. It's really a course on power of attorney, but I thought that I would maybe some of these. 628106A, a power of attorney executed on after the effective date of this article, January the 1st, 2017, is valid if it complies with section 628105, which is if you sign it with 2 witnesses and a principal, you got a power of attorney, generally. South Carolina, it needs to be attested in the same formality as a deed, which I've just said. And the section mentions Title 30, which is the title that tells you about when a deed is valid and a will and so forth. So you can look at those sections. Let's look at something else that would be, photocopies are electronically transmitted copies of an original power of attorney has the same effect as the original. That's helpful. I'm going to get to the real juice here in just a minute if I can. I thought I had these tied together with a staple, but I didn't. Look at those sections. I'm not going to give you all of them.
Does the durable still have to be filed with the...
Well, okay, that's a good question. I'm going to get to that. Yes, if it's going to be operative. Here's an important section somebody was going to talk about, I think. Guardian actions. This is an important section. It says a principal may nominate a conservator or guardian for consideration by the court if protective proceedings for the principal's estate or person are begun after the principal execute the power of attorney. So essentially this section is saying, unless the court says otherwise, it should be given some expression of who the person says in the power of attorney that they would like to be a guardian or conservator. That's pretty important. If after a principal executes a power of attorney, a court appoints a conservator or guardian of the principal's estate or other fiduciary charged with the management, the agent is accountable to the fiduciary. So in any event, take a look at that. Effectiveness, you were talking about filing. 628-109 says it's effective when executed unless the principal provides in the power of attorney that it becomes effective at a future date or upon the occurrence of a future event or contingency, such as incapacity. If a power of attorney becomes effective upon the principal's incapacity and the principal has not authorized a person to determine when he or she is incapacitated, then this section will say who can make that determination. Let me read this because this is important. If a power of attorney becomes effective upon the principal's incapacity and the principal has not authorized a person, and you're drawing these powers of attorney, you ought to think about authorizing a person. Or if you don't, or if the person is to be determined whether the principal is incapacitated or the person authorized is unable or unwilling to make the determination, the power of attorney becomes effective upon a determination in writing or other record by a physician or a psychologist, or guess what, an attorney at law. How about that?
What?
An attorney at law. The court of common jurisdiction or appropriate government official. Okay. Here is what is probably the most important thing for me to leave with you, is incapacity. Incapacity in 62.8.102 means inability of an individual to manage property or business affairs because the individual, then it has A, B, C, so forth. A is impairment. B is missing, Detained, is that important to us? Detained, including incarcerated in a penal system or outside the United States and unable to return. Those are important sections that I would call to your attention and ask you to read them. And they came into effect just recently. Anybody have a question about those? You asked about recording. We talked about that. Yes, it does need to be recorded if it's going to be effective.
The durable has to be recorded, but the power of attorney for children, I don't believe, has to be. Nor
This
does,
deals with general powers of attorney.
yeah,
It is not about children.
and also the healthcare power of attorney does not have to be.
I think that, I can't talk on that. I can't speak on that. Does anybody know? I would think that that's a different section and different, I would think that that would be under guardianships, conservatives, in that section of Title 62. I don't think it'd be under 8, powers of attorney. I think it'd be under,
Unless it's been changed, they didn't previously have to be.
unless what?
Unless it's been changed by the statute, they didn't previously have to be recorded.
I don't know. These were significant changes, I believe. When I saw them, I was really surprised. I said, wow, they anticipate some of the issues that we might see. Okay, I said there was general number 1, so we've kind of just gone through some of the things you might think about, and if you've got some time to plan. If you're in a crisis mode, you might be looking at foreclosure. I can't teach foreclosure today. It would take us a long time to do. And there is an excellent book that is there. Here it is on the floor. I thought, I will do some advertising for Berkowitz and others, my law partner, Drew Radiker. I don't know if there's any, I haven't heard about any income from this thing. I haven't seen any coming into
It's all donated to this wonderful organization called South Carolina Appleseed.
Oh, I got you. All right. Well, I wondered about that. There's a marvelous book if you are going to. I realized I was on the editorial board of the first edition. I didn't make it to the third edition, but I was so recently a judge back then that they put me on there. Anyway, this book is an excellent book for those of you who have not discovered it. Has excellent, even has some suggested defenses to foreclosure actions. It's got defenses in there. And it's got them written out for you. Here's an answer with a counterclaim. So I do commend this
And they're
resource.
all brilliant. They're all
I do commend that. And also this book has a lot of resources for you in it. It has a bunch of resources that I won't take the time to talk about right now. If you reach in a foreclosure situation, remember there's a South Carolina organization called South Carolina Help, which you can find online, which is a great resource. The federal programs that help folks in mortgage foreclosures expired, most of them, I think, in January of this year. Justice Toll's order on assisting folks in foreclosures in workouts did not expire. It's still there. And so mortgage companies will work with you on workouts, even if you're in default. If somebody comes to you, we have many times, file motions. I have gone ahead and filed answers, file motions, whatever, to just get in there. If your client comes in there in some of these situations, these debt cases, file an answer. Even those of you who worked in this area, credit cards. My goodness, you can get a deal on a credit card. You can get it cut down 40% just by calling them just about. Put in an answer, you might get it down to 10%. Now, let me suggest something. Many of the people that you're going to be representing in this area are not going to be able to respond to a judgment. So some of the planning I would do is the planning that they may not be able to respond to a judgment. So maybe a judgment wouldn't hurt so much. But I'm not suggesting let somebody go into default. But if they're in default, you know, it may not be so bad. If they come into your office, you're going to want to know the things you would want to know if you're defending. When were you served? Sometimes what they were served with was a letter saying, we're going to foreclose you. You know. So make sure you know what it is. It's a letter, not a pleading. In the POA, in the power of attorney that I mentioned, be sure to put in your power of attorney about hiring attorneys, asserting defenses. Be sure in your power of attorney, if you're going to have a power of attorney that covers these folks, I would think about what are the things that you might do in defending that you might want to put on that in that power of attorney that allows the attorney to be able to do. Consumer debt, be familiar with Title 37. I'll move past foreclosure. It's too vast. If you want to call us about foreclosure, you're welcome to. I consider Drew one of the state's experts in that area. And so we'd be more than happy to help. Consumer debt, be familiar with Title 37, of course, the Consumer Protection Code. The Fair Debt Collection Act, if you don't have those volumes in. Of course, there's till arrest for those kinds of things. If you're going to get heavily into defending, that you want to be familiar with. Again, I said, consider if a client has defenses. I mean, you got to remember Rule 11. Don't just get the book and throw all these defenses up on the wall. Of course, I'm not advocating that at all, of course. So there has to be some basis to it. But put in a vanilla answer, give you room to negotiate, give you some time. Even though you don't have any real drop-dead defenses. Again, I mentioned consider working out. Most of these creditors are going to be interested in working something out within your power of attorney. You need to have given the individual who is the attorney that power to be able to negotiate with those creditors. Bankruptcy. Unless you're especially in bankruptcy, you're not going to be handling bankruptcy. You'll be referring them down the street to a bankruptcy attorney. Many of these folks might not have the assets to make a Chapter 13 work and a 7. Well, what is that? You can do a Chapter 13 yourself. You can look at the debt if you've got the time or inclination or you want to help. You know, you can look at the debt structure and try to work with the creditors. In effect, almost the same thing that a 13 might do. You can work out, giving the house back or with no deficiency judgment, that kind of thing. In workhouse, here are some problems you might encounter in these programs. They ask for Social Security numbers. So you might not even have access to some of these programs if you don't have a Social Security number. So be thinking about those problems. How would you surmount that? I don't know how you would surmount that. Maybe Sue has some ideas or some of you others have some ideas about that. But these modification programs and so forth are usually going to be wanting a Social Security number. And many folks that you might be encountering will not have a Social Security number.
Sometimes they'll take tax ID numbers.
Well, that's a good tax ID number. They're going to have tax ID numbers.
Yeah, they can go get one.
Can they? Just send, you can do that, can't you? Online, just get a tax ID number.
Go to
That's
the
a good
IRS
idea.
office. They can go to the IRS office and fill out forms as well.
I'm not, that's not my area, and that's more in the accounting area, and so I really can't advise about that. But that's an idea that there may, I only have one more thing. Thank you. Has anybody got any questions about any of that? Yes?
Judge Harrison.
I knew you would have a question. And I appreciate it, but I didn't ask her to ask this question. Now, Bill, since I have a hearing problem, is my interpreter for questions. Bill, please listen to the question.
Yes, I'm going to listen very carefully.
You mentioned
the power of attorney, and we were talking about a power of attorney for children. And I don't know that that exists in South Carolina.
It doesn't.
As such, I was looking at, I believe I have read the statute, I'm struggling like everybody else. And with all those powers, I saw nothing dealing with children, and yet the probate court puts it in family court. We really don't have the guardianships for minors.
What you,
Has anybody made one up for children? What?
That's what Jeff was saying.
yeah. I'm not sure.
That's actually what I'm gonna talk about.
Yeah, we got a speaker on.
You gonna talk about it?
Cool.
Because of
Coming up.
You're good, Jen.
Henriette, you're just anticipating. You're anticipating, as I knew you would. There's only one other thing I want to tell you. There's a fine plain, you know, you might find yourself in court and somebody want to intimidate your client, the immigrant. There's a beautiful plaintiff's memorandum in support of motion for protective order in, it's in your materials and the materials that they put online. It's in a case in the 5th Judicial Circuit in 2015. It was written by McGowan, Hood, and Felder. And it's just perfectly beautiful exposition of the law of protection of people whose immigration status might be questioned by lawyers in courts for various reasons. And so that's as simple as I can say what that is, but I would highly recommend you take a look at that. It's a very well-written, and Jean Toll, the Honorable Justice Toll, retired, actually ruled, I didn't see the order, but I understand that she ruled for this plaintiff making this. This was a wreck case. I mean, this is a wreck case. This is what it was. And, you know, the plaintiff's claiming like $300,000, had serious injuries. And so the defendant, doing their job as a defense attorney, decided that they want to inquire inappropriately, the plaintiff thought, into the immigration status of the plaintiff. So read that, I commend it to you. That's all I have to say, unless there are any other questions. Yes, sir.
Just a question about credit card debt and unsecured debt. When you're talking to somebody who's
Secured debt.
Secured debt or unsecured debt, actually, is what I was asking about. So if you have somebody that has unsecured debt who's facing the possibility of deportation, and there's nobody else that has a name on the debt, then I mean, really, the advice might be, don't worry about that, just let it go.
Let's let them try to come up, not
Yeah,
Guatemala.
let get it from.
Well, you know, I think that you work it out depending on the situation. As far as you as a lawyer, I guess you're not going to confront it actually until there's a lawsuit or a demand or something like that. I think that as far as counseling is concerned, I'm not exactly sure how you would counsel in that.
Well, you know, I would tell them, don't worry. I mean, if somebody is worried about if they are deported, and it's unsecured debt, and it's a credit card, and they have no other assets, let them come after them. You know, I mean, it's not gonna.
I wouldn't tell them not to worry about it, but I would tell them what the likely legal consequences of particular actions are, such as not paying the debt and ignoring it. These are the possible consequences, and if they can find you in Guatemala, good luck.
Well, and there's no wage garnishment in South Carolina, so you know no one is going to be responsible for that debt. I mean, I think in the scheme of everything that person has to worry about, that is the least.
It may be down on the, but there are a lot of things with that, though. I mean, you might not want a judgment come back and there's a $50,000 judgment when it could have been worked out. So I don't know. You might attack the judgment if they got a judgment and they said they served at home and they were in Guatemala. You know, you might have an effect. It may be a bad judgment anyway. So I think you would look at it along with everything else. You look at it and depend on the circumstances. I think that is an answer that, well, if your judgment proved anyway, it really doesn't matter. We often don't offer that counsel. We offer defend it, work it out, do something so that we can. But I understand.
Yeah.
I understand where you're coming from.
If someone is low income and they have no other money,
I understand.
working it out is the same as not being able to pay it, because there is no money to pay it.
But you might work it out with a low repayment plan.
That's right.
Or some kind of, you know, putting it off. There are ways to do that.
Yeah, it depends, to some extent, Jimmy, it depends on how reasonable the creditor is. And they're often not as reasonable as you hope they would be.
Well, the credit card, you know, the credit card companies aren't. And they're gonna let them file the lawsuit and then file an answer. That's gonna time up. And then you're gonna talk to somebody. You're gonna talk to a lawyer, not the credit card person on the telephone, who's sitting in there on a computer screen, you know, saying to you what the computer screen says. So, my counsel more is active involvement with that debt action. Even though I understand.
Yeah, no, I mean, I think if someone's being deported and they're gone, and they're, you know, while they're here, if they're not going to be deported, then of course you want people to pay their debts. But if someone's being deported, I think there's many more things that they're going to be, like what's going to happen to their children, or if they have a home, what's going to happen to their home. I think the credit, even the home, I mean, the chances are if you've got a credit card debt, there's probably, if you're judgment proof, there's a lot of other things I would put in priority of worrying about than trying to come up with a payment amount.
Yeah, but if we have it, we don't deal with that.
Yeah.
If we have it, we'll deal with that. Yes, ma'am?
I don't know the likelihood that somebody who's deported will one day in the future be eligible to apply for reentry, but I would think that having civil judgments against you in the country that you want to move to is something that might come up. So, I mean, I guess I agree, it makes sense to try to do something to at least say, look, I can't pay it, but I know it's there.
The point is, you might not want judgment against you for some reason. Applications for reentry, if you got it, you know, how's your credit, that kind of thing.
I mean, I think that's a consideration too. Like, if you overstay a green card or some status, and then you think you still have a chance of coming back at some point in the future. So you had identification the whole time, and I mean, but it's maybe not as big a consideration if you didn't ever have status, and you know, and are not expecting to be able to come back, and it's not without going through, you know, the same process you got. And how long is it?
If you're deported, you're typically banned for like 10 years.
The judgment expired.
And so does statute of
Children
limitations.
staying in this country,
I would
assume you would try to get back in.
I encourage giving it a shot at working it out, and maybe that's not in the program, you know, or if it's already happened, maybe, like Sue said, forget it. There's one other thing that I meant to mention, and a lot of other things, you know, you always, what you meant to say. But a lot of these people don't understand in their culture, because someone's a complaint might mean I'm going to jail. You know, so they come in and they're all panicked, you know, so they got someone's a complaint, they think they're going to jail. So some of the thing that you do is to, you know, make sure. Foreclosure, we get any number of people come in and they think they got to move out tomorrow. I mean, you know, we can hold it off a year or more, and, you know, without even hardly blinking our eye. And so, you know, they don't have to move out tomorrow. You know, and they've been told that, gotta get out. So, you know, one of the first things you can do if you get something like that, even if you're not gonna defend a foreclosure action, is let them know they don't have to get out tomorrow. It'll be a while.
What you mentioned right there is one of their biggest concerns.
I'm sorry?
What you mentioned right there is one of their biggest concerns. They think if they're sued and they get it, they can go to jail for not paying a debt.
Going to jail and get it back.
And that's a big relief to a lot of them when they come in.
Yeah, and just there ain't a amount about that. That, you know, we don't, debtor's prison went out with the revolution, although there are some judges who still do
Well,
that
the new
illegally.
debtor's prison has to do with criminal fines and penalties,
Yeah.
so that's a different.
Yeah, it's a different kind of
That's a
issue.
different CLE from.
Not
the
civil, not civil,
Yeah.
yeah. We won't get into that, but yeah, generally they're civil and you don't go to jail, and they need to understand that. Anything else? Well, thank you all very much, I enjoyed it.
Thank you.
And so what I'm going to talk to you guys today about is protecting families and children. I know a lot of you have concerns about that, especially related to people who are maybe undocumented and facing possible deportation. So we'll talk about a couple of different things today. Guardianship, custody, school authorization, and healthcare. I think those are pretty much what everyone is on everyone's mind right now. So guardianship actions in South Carolina are for primarily disabled adults, but I find that because a lot of other states do guardianships in relationship to custody of children, people will come in and say, I need guardianship, but that's not really what they are asking for. So custody is costly. It's something that, you can't really delay. There's a $150 filing fee, you've got guardian ad litem fees, mediation, multiple hearings, and the court's looking at something called the best interest of the child. I'm not telling you guys anything that you don't already know. So this, getting custody over a child for the potential parent who may be worried about possibly getting deported, that's a lot of possibles and potentials. So that may not be the best answer. Another thing that people are kind of worried about is school authorizations. So the first thing would be in school enrollment. And so somebody just came up to me and was like, how do I get these kids enrolled in school when the district won't accept a power of attorney? Well, there is an affidavit. It's South Carolina Code 596332 that allows kids to be enrolled under certain circumstances by somebody who does not have custody of them. One of those circumstances is if a parent is incarcerated. So I would say that the detention of a parent would mean that the parent is incarcerated and would then qualify for enrollment under the affidavit. The affidavit is a statutory form. It has to be signed by the person who's going to enroll the child, and that person is accepting the authority to, make school decisions, medical decisions for the kid. It's just a little affidavit that goes straight to the school district. It has to be notarized. We do a bunch of these at Legal Services. So if you ever need any guidance about that, you're more than welcome to reach out to me. Once the affidavit is presented properly to the school district, they're supposed to enroll without further delay, period. No, make you jump through 10 more hoops to get you there. If the school district is requesting that, that's usually when I send the district a letter, or I make a phone call depending on whether or not I'm familiar with the district. And I say, hey, guess what? I'm going to sue you guys if you don't enroll this kid like today. Usually, they enroll. I've only had to threaten, an injunctive suit maybe twice since I've been doing this, and I've never had anyone say file it because they're going to lose. Again, I really want somebody to say that to me because I really want to file one of these, but it hasn't happened yet. So again, I think that this is a very effective tool. A parent can or a custodian of a child can redo this every single school year. It's good for a whole school year. So there's no limit. You don't have to get custody within 3 years. There's no kind of secret limit or anything to that. So this can be used theoretically for a very long time. McKinney-Vento is the federal law that deals with children who are maybe homeless or have unstable housing. The definition of homeless or unstable housing is very, very loose, and it's just a fixed, adequate nighttime residence. So if you're staying on somebody's couch or whatever, that could be unstable housing. So that could also be another avenue to get these kids enrolled. The other thing that I believe was talked about a little bit earlier was birth certificate issues. So that is something that we do see frequently where the name is wrong, the wrong married, not married, the wrong husband is listed on the birth certificate. They didn't put both surnames on the child's documents. And that's definitely something that could potentially become a problem. Another issue that maybe you guys haven't thought about is that a child has no right to their birth certificate until they're age 18. So if a parent is leaving the kid here with someone, that kid doesn't have a right to their birth certificate, so a parent's going to have to give that right to somebody to request the birth certificate in the event that they need them in the future. Everybody understand what I'm saying? Yeah? Okay. Then another area of concern may potentially be special education. So if a student has a disability and maybe starts to have issues in school with learning or accessing the curriculum, somebody's also going to need to consent to potentially having a child evaluated for special education services and then consenting for those services to be provided. So that's another important factor that probably somebody who doesn't see this kind of stuff doesn't really think about. So healthcare concerns, again, consenting to medical treatment for the child, access to the immunization records, because that's something that the school is going to require.
Let me ask you something before you move on from that last comment. The implication seems to be that a power of attorney should be as broad as possible, be as generic as possible. Do the school districts require a specific thing that says you must have the power to request special services for this child?
The document that I've drafted, and I'll kind of get to this in a little bit, is very specific in delineating out those powers, because I wanted to make it very clear, and I didn't want somebody to come back later and be like, well, it doesn't specifically say it. That was something that I would see a lot when I was in the probate court, would be that people would be coming in filing for guardianships and conservatorships for incapacitated people because the power wasn't clearly laid out in the power of attorney. So, and we'll get to that in just a minute. But again, access to the child's medical records and access to share those medical records with other providers should they need to. Okay, so that would be maybe to the school if the child was being evaluated, or, you know, from one doctor to another doctor. All right, so how to prepare? I don't really have a good answer for you, and I don't think any of us do, and that's the problem. But I think that the best answer is going to be a power of attorney. And so I'm going to talk to you guys a little bit about the different kinds of powers of attorney and kind of what they're commonly referred to as. So basically, you have your non-durable powers of attorney, durable powers of attorney, special or limited powers of attorney, and a springing power of attorney. Medical powers of attorney and healthcare powers of attorney, we're not going to talk about because that's statutorily laid out, but that's for an individual giving their, I don't want my organs to be donated. So that's for them as the individual, and that would be the person that would be detained and possibly deported. So I know this was talked about a little bit. The code section did just change in January. It was updated. I have sites to the code sections for all of these slides in here, so that way you guys can access this later if you're like, hey, wait a minute, what section is that, rather than having to dig. So basically, to execute a power of attorney, you've got to have 2 witnesses, a notary, and then the person has to have capacity. So that means it's contractual capacity to execute a document like this. All right, and then, so the Uniform Power of Attorney Act, again, it lays out specifically all of these different powers and authority that you're giving when you're giving away a general power of attorney, and it kind of says if you invoke one of these, you're invoking all of these for each individual code section. So they're each individually laid out in the codes after them. I'm not going to go through them with you guys because we can all read. And so the other thing that it does is it gives probate court concurrent jurisdiction with the circuit courts over all subject matter related to the execution, creation, exercise, construction, and termination. Okay, so that's something that's also a good thing, because for me anyway, I find that it's much easier to get into probate court sometimes than it is to get into family court. So let's talk about specifically durable powers of attorney. Sorry, I like to include memes to kind of keep it interesting. But this cat is absolutely correct. Powers of attorney, make sure you want them driving, otherwise you're in for a bumpy ride, okay? So they're effective on the date that they're executed unless they otherwise specify. And that would be more like a springing, and we'll get to that in a second. But generally, it covers the individual's health and financial concerns, and this is a dangerous document. In my time at Legal Services, I have seen these go horribly, horribly wrong, and in fact, I hate doing durable powers of attorney because I feel like you open your client up to so much potential heartache and such a nightmare with these documents. They're very open to abuse because, again, you're giving somebody kind of the authority to conduct business as if they were you. So a lot of times when I say that to my clients and I say, this person could go out and buy a car in your name, run up credit card debt, sell your stuff, is that really what you want? And that's scary to a lot of people, and it should be. I can't tell you how many times I've, from an elder law perspective, gotten a call from the little old lady who's been evicted from the nursing home because her power of attorney has taken off with all her money, and now she can't pay her bill. And they're like, you can't stay here, okay? So it's very, very dangerous. Now, the other thing with a power of attorney that you need to keep in mind is that the ability to recover from somebody who misuses this document is very difficult, because chances are, if you're gonna steal from me as my agent, you probably don't have anything that I can collect on in a judgment, okay? And law enforcement is not exactly keen on prosecuting these. But I had a case once where we had this girl, dead to rights. She totally abused this document. And the police were like, yeah, we're not gonna prosecute her, because she knows the victim. She'll probably just die or drop out, the client. So police are not willing to kind of investigate these like they maybe should. The other thing that you have to consider too is that this population is not going to want to go to the police if somebody misuses their document because they're undocumented. So that's another thing to kind of consider when we're talking about durable powers of attorney. They're very, very dangerous. When used properly, they're an amazing document and they're wonderful, but when they go wrong, they go really wrong. Okay, so spring.
This is on the civil side, but
sure.
I saw, and Graham was in here earlier, but you need to put in your power, or have to put in the power of attorneys, that the person given the right to act on their behalf do not have the right to enter into any contract with an arbitration clause. And because that can greatly affect their ability to recover if they're killed or whatever in a nursing home or a hospital or whatever. So you need to add that clause to your powers of attorney.
That's great. And are the questions able to be picked up for the video?
Could you repeat?
So basically it was a comment that said that you need to make sure that you limit the ability for your agent to sign on to arbitration clauses, because that could affect the ability to recover in a nursing home case, or if you were killed in a car accident or something like that, right?
Exactly.
Okay. So the next thing that we'll talk about is, and that's absolutely right. So the next thing that we'll talk about is the springing powers of attorney. And so basically that you're putting a condition in that power of attorney for it to become valid, okay? The springing event should be very clearly explained. And the way that I've seen springing powers of attorney previously would be like, this specific physician will sign off and say that I'm not competent to handle my own affairs, and in which case then this power of attorney becomes valid. So I think that the way that you would do this would be an attorney would have to sign off to say you've been detained, and that would need to be specifically laid out in that springing power of attorney. That in the event of my detention and or deportment, that this attorney can sign a statement saying that this document is in effect. You look confused.
So you would name an attorney that could verify that you've been?
Right. Ideally, I would recommend, again, that it says any, but the statute says any, but I would recommend that it's very specifically laid out, because what I've seen with springing powers of attorney back in my days in probate court was that places didn't want to accept the condition. So they would be like, if I'm incapacitated, so the person would get a letter from the doctor, and then, Wells Fargo would still be like, we're not taking this, because how do we know that this doctor is who they say they are? How do we know this was actually written by that doctor and not something that you forged? So there's a lot of concern there about exactly what it should say. So it makes me nervous about a springing, because again, it's something that wouldn't take effect until it's too late to fix it. You know what I'm saying?
I wouldn't, as an attorney, agree to do that because it creates so much liability.
That's true too. That's true too. But the statute does say that it can be a physician or an attorney. So again, and the other thing with that as well is that that's going to create some sort of privacy concerns. Some people are not going to necessarily want others to know that they've been deported or that they're going through these proceedings, because they may have presented themselves as being documented the whole time that they were here. So, and that may run into some kind of discrimination issues that a child may face in school if you're presenting this to them and that's kind of made clear that parent's been, you know, deported or is going through the deportation process.
You could say presentation of a deportation order or deportation.
Right.
That can be hard to get though, and so that's part of the problem.
Right, so I wanted to give you these different ways of potential solving this problem, but then tell you how I feel maybe some of the pitfalls of all of them.
So you have to have a specific attorney that could sign off and say, I know that this person's been deported.
Yeah, so I would say like your immigration attorney would probably, somebody who's handling your case in immigration court could probably sign and say, this person has been detained, right?
Problem is what if you've got, you know, ICE comes in and does a raid, or somebody gets picked up and didn't have an immigration attorney?
Exactly.
Okay.
That's what I'm saying. These are like the
It's like a
pitfalls.
voluntary departure or, yeah.
Right.
Just to make it clear, you don't have a document in your files that call, but it's called springing power of attorney, right? Or do you?
I don't do them. I don't do them because I've never seen it work. So, I mean, there are forms out there. I have seen forms that say springing upon this event, then this power of attorney becomes valid. And they're usually very simply laid out, and there's, you know, a box that's checked that says this condition's been met and see attached or whatever. But I think that this is one of the problems with this document, which is why I think we don't lean on this document as much as maybe people initially think that we do. Any other questions about that specifically? Correct.
You can always go to family court and ask for custody if there's a problem with somebody recognizing this.
Right. That's true. You can. You certainly could always do that. And so the other thing that I want to talk to you guys about is a specific power of attorney. It contemplates, yes ma'am.
Wouldn't you say that the new act, though, that there are consequences for not honoring the power of attorney, so springing might have a little more weight than it did before? I mean, because I never liked to do them either, because it's hard enough to get them to take regular one.
Right. That's right. I mean, you're absolutely right. And there are consequences for not accepting those documents in the new statute. But I haven't seen how that's going to play out yet. And you know, it might be reasonable to assume, like if a judge assumes that it's reasonable, I mean, and the person has met their burden of proof, then, you know, you might still be in the same boat, and meanwhile you're spending all this time and effort to litigate this issue.
You could put a provision in there if both parties agree in writing for it to take effect. But that assumes that you're going to have time to react and you know where the person is in order to get the decision, to get the signature.
Right, which is, again, I think that's the problem with the springing. I think that it is not necessarily the best option in this situation. Did you have a question?
I did have a question about the specific power of attorney with regard to children.
Mm-hmm.
And
I'm just getting there.
Yeah, because have you actually had it? My experience has been the schools want a school affidavit or a custody order, but they're not keen on honoring a specific power of attorney.
It depends on your school district, but again, if you've used the affidavit for enrollment to get the child in school, on that affidavit, they're agreeing that they're going to take responsibility for the kid. So I think that would be sufficient for the school district, and they wouldn't necessarily have to see that. I definitely think it depends on your district.
There's also medical providers, insurance companies, you know.
Right, I'm getting there. Give me a second, let me get there. You're getting ahead of me. All right, so the specific power of attorney, again, it contemplates those specific circumstances. It can be for a specific time or a specific purpose. So like I'm going in for knee surgery and I need somebody to handle my affairs while I'm incapacitated. I have done a sample document of this up that I hope will be helpful to you guys. It kind of contemplates all of these different things: standing to appear in court, authorized medical care treatment, medical records including HIPAA stuff for the child, school enrollment, educational rights under state and federal law, and spend money that parent may receive for the benefit of the child. Let's see if I can get this to pop up. Maybe. I can't get it to pop up. So basically, it's in your materials. I'm getting that document translated into Spanish for you guys as well, and I will share that with Appleseed as soon as it's done, which is my understanding that they'll update the information then. I've just put something very wrong. Sorry. Okay. There's probably gonna be like armed people running in the door in a second. Security box. Yeah, so, okay, here we go, I'm back. I got it, thank you. So anyway, I want you guys to take a look at that document. I think it can be tweaked to fit whatever situation, but I hope that that contemplates a lot of those things that we've all been asking about, and hopefully it will be effective. And so the next thing I want to talk to you guys about is terminating a power of attorney and kind of what the code section is for that. So there's some criteria there. If the principal dies, becomes incapacitated, if it's not a durable power of attorney, or they revoke it, or the purpose is accomplished if it's a specific one. Or if the named agent dies or becomes incapacitated or resigns, then that could potentially terminate the power of attorney as well. And then revoking a power of attorney, again, the principal has got to have capacity to do that. They must sign or direct for somebody else to sign for them. It's 2 witnesses and a notary. It should be recorded. That's the other thing. I think that all powers of attorney should be recorded, other than obviously the healthcare, which that doesn't have to be. But in the cases of things like this, I think it's probably good to get these recorded. And the agent, of course, has to be notified. So one of the things that I've also provided to you guys in your materials is a fact sheet for agents to kind of go over with them. So if you've appointed somebody as your agent in a durable power of attorney, to kind of let them know what the criteria is, like what they can and can't do with their power of attorney, kind of what their liability is. And that's just because I find that sometimes when people take advantage of a power of attorney, it sort of starts out innocently and is sort of a gray area, and so that document makes it clear, and that's going to be in your materials as well. So there is the possibility to designate co-agents or successor agents, and I don't do that because co-agents must act together, and how can you get 2 people in a room to do whatever needs to be done at the same time? I find that that's a huge problem. And then, of course, if they disagree, who makes the final decision, and that could become a source of litigation as well. You can also name a successor agent, but again, I'll caution you about that because you'll also need to provide proof that that successor agent is the one who's authorized to act. So in contemplating doing these documents, they need to be selecting somebody, don't select 98-year-old grandma, because that's going to be a problem. Select someone who is in good health. Obviously, we can't plan for everything. You could get hit by a bus tomorrow. So planning for all of those things and putting all of these things in place. Okay, so an agent can resign. They can be like, look, this is not, I don't want to do this anymore, and they can resign. So that's another potential issue, which I think is why you should meet with these agents. The person who's appointing that person needs to talk to that agent. You need to talk to that agent and make sure that they understand that given the circumstances, because this is sort of a high stakes deal when you have somebody who's potentially leaving their child behind. That's a big deal. And as a parent, I can't imagine leaving my child behind and going to another country, okay? So that is going to be an just unimaginable amount of stress on this person. So whoever signs up to be the agent really needs to be ready to accept the responsibilities so that you don't have somebody quitting or saying, you know what, this is not what I signed up for. So they need to understand what it is that they're signing up for. So duties of an agent once they're appointed. So basically, again, they've got to act in the principal's best interest and in good faith and within the scope of authority granted by the power of attorney. There is some liability on agents, and basically what ends up happening is, again, that they would have to restore the value of the property and attorney's fees, and that's pretty much it. I know that I went through that pretty quick. Does anybody have any questions about specifics? Sure.
Where do powers of attorney get recorded?
Great question. I didn't say that. In the Register of Deeds office in the county in which the person resides. So if your principal is a Richland County resident, it would get recorded in the Richland County Register of Deeds office. There's a small filing fee for that. It's like $15 usually, depending on your county. They vary.
Do you have to record power of attorneys for children? My understanding was you didn't have to do that.
So if you're doing the specific for saying I, parent, am giving my rights over this child away, does it have to be recorded? No, but no power of attorney has to be. But again, I think it's best practices to record it, because then everybody's on notice that it exists, and inevitably someone will lose the original, because that's what always happens.
You're saying that's in the county and residence of the principal?
That's correct. That's correct.
Does anybody, I drafted something very similar to what you gave out in the materials for a client. She attempted to record in Richland County, and they refused it. And Lexington 5 wouldn't take it as at school, so.
Rainville's the same way. They won't accept durable power of attorneys dealing with the general power of attorneys, not specifics such as this.
Okay. Well, like I said, I think if it meets the recording requirements, and they're supposed to record it. And so I know that there are certain offices that maybe have cavalier people who think, or whatever. But again, if it meets the requirements, which is the 2 signatures, the notary has the probate section on the bottom, then it should be able to be recorded. But again, and I understand that some of the school districts are not willing to accept them. It depends on your district. Sometimes a phone call might help with that. I have done these and had them accepted in Richland, Lee, and Kershaw, I think, right off the top of my head. Yes, ma'am.
You were saying something about that co-agents had to work together, but I think when I read the statute that they could work independently, I didn't feel like it required them to agree. Both sides, I think it was the bank account that required 2 signatures.
Okay. My reading of it, it did, unless it specifically lays it out otherwise. So, and again, like I said, I think co-agents makes it difficult. I would just go with 1, because I think that when you have 2 people, you're more likely to have something go wrong, I feel like. Yes, ma'am.
Another question, sorry.
Sure.
But when somebody really doesn't have anybody they can trust, is there any, do y'all know of anybody, and that they can be referred to as a fiduciary or somebody, of course, being guardian for a child is different, I guess, but like what would you do? What is their option? Like when you're helping them problem solve this kind of.
Well, I would hope that there's somebody that they trust to leave this kid with. I would really, really hope that, because I don't know that there's any sort of, for conservatorship, there would be some type of fiduciary agents that would be available, and there maybe are some there are some like guardian stuff that may be available, but again, it's not something that's common or that I would even recommend. There needs to be somebody, I think.
If you don't have someone, yes, that's going to be the option.
Right.
So that's something you can.
And nobody wants
your
that.
child abandoned.
One other option you can do is, before this happens, is you can get joint custody with the person that you trust. A lot of times it's a parent, sometimes it's a sister that counts as status, and that way there's not a problem with this issue.
Right.
And lasts until the child turns 18.
Right. So that would be the other option, would be joint custody.
And that Does that require a guardian advice?
No, as long as the parties agree, it does not. You don't have to go through mediation. It can be done fairly quickly because it is consensual. If it's not consensual, then there's no reason to do it.
I would caution you too about what county you're filing in, because I know that there have been some instances in the past that I'm aware of counties where when one of the parties is undocumented, the judge asks a lot of questions about that undocumented person. And I know that's not appropriate, but it's happening.
The way I handle that is this is a right of the child, particularly one that's born in the United States, and to deny them this and not to give it to a child who has 2 American citizens is a denial of due process.
Right.
And that's how I get around that.
Okay. Any other questions or anything?
The affidavit you mentioned earlier.
School
for
enrollment
the school
affidavit.
district, yes. Gotta be careful how I ask this question since I'm a board member. I just want to make sure I understand this. If a school district does not accept that and tells the parent, you have to go to court, you will only enroll this child if you have a court order, because they are trying to stop parents from jumping across the district to get their child in because they believe it's a better district. Your position is that that is a violation of state law, and they must allow that child to be enrolled.
Okay.
If the affidavit is signed.
I'm gonna stop you because you said something really important there about parents, district hopping to try and find the best district. That is not what that affidavit contemplates. So
It's contemplated, but it's sometimes used for that reason. Or attempt is made to use it.
there are districts who who have investigative services who look into these, and you can be, there is a liability for signing this form fraudulently. Okay, so that's not at all what the form was intended for. If it's used that way, that's an improper use of it. But when I have a parent who comes to me, or not a parent, but somebody who's in charge of a kid, grandma, auntie, brother, I've had a lot of, older brothers who have much younger siblings that they have them in their custody. When they fill those out and they meet the criteria, parents detained or incarcerated or no longer in the picture, and I present that to the district, they must follow it. And if they refuse, I'll send them, if it's a district I work with a lot, I'll give them a call on the phone and say, hey, what's up? And they know me, and they'll be like, okay, send the kid to school tomorrow. But if not, I'll send a letter and I'll say, hey, you have X amount of days to enroll this kid, usually 48 hours. And then I'll also CC the board members on that letter. Because you guys don't want me filing a court case. Because that's that's the next step, is I'm going to file that. So usually that resolves it. Like I said, I've not had to file an injunctive case because nobody wants that. And kids have to be enrolled in school, and that's the district's job, enroll them. So.
I totally agree.
Yeah, absolutely. Yes.
I have a question and a comment.
Sure.
The question is, if the person's already been removed from the United States, I'm presuming that a notarized document, they can do the same thing, getting it notarized at the U.S. consulate, and it would still be effective here.
So a power
as long as they comply with all the other requirements.
Right. So if a power of attorney is valid wherever it's executed, so whatever the law is where it's executed. So that would be an interesting, probably legal research paper that would have to be written on what, if they're actually inside the U.S. consulate, is that, would it then be
the
this?
Mexican consulate takes the perspective in Raleigh. You're, inside here, this is Mexican law. They do take that perspective. So I wonder if our U.S. consulates in Ciudad Juarez take the same.
Right.
Because I know you can go to the consulate and get documents notarized
Absolutely.
there.
Yeah.
But the scenario where the person's already been deported and needs
Something.
Is
Absolutely.
that how you
And I don't know the answer to that question. That's a really great question. So.
my comment.
Yes.
This scenario where you have a single parent and where you would need this because they're going to be deported and their kid left behind. This is like one scenario where immigration actually is very sympathetic to the person. I've never had to take a single parent and put them on a plane and leave their kid here, but then, the kid's gonna have to move to DSS custody. So if you're involved in a situation like that, like, talk to ICE or talk to an immigration lawyer who's got a relationship with ICE, because often that can be stopped.
That's good. That's great to know. So basically, what the comment was that, immigration and ICE, they're very understanding of a single parent who has just this child that would end up in DSS custody, but for the parent. And so that you should talk to somebody about that because they're very sympathetic to that.
Historically
speaking.
I don't know about the future.
Of course, yeah. And nobody has, we don't have crystal balls to predict the future, unfortunately. So, yeah. And I think that's kind of the fear, is that we need to be prepared for this stuff. I think people really need to start thinking this through and preparing. The lobby guard thing, and people need IDs to go to the school. They're not going to release a child to you if you don't have an ID. I can speak to that too. So even when I go in and I'm representing a parent and I've been in the district like a million times and they know me by name when I walk in, I still got to show my ID. So, any other questions or anything? Yes, ma'am.
What was the code section on that school activity?
The school enrollment affidavit is 596332.
And we'll also have this in your packet materials. It's also on our website.
And if you ever, the affidavit is kind of statutorily provided, but again, if that's something that you want a specific, already clean copy of that, you can email me and I'll be happy to send you a copy of mine, that's fine. Any other questions or anything? All right, I think I'm done.